We're going to get started. So good morning. I'm Parole Officer Tricello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Keenan Campbell, inmate number 432941. Today is Thursday, December 11th, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Robinson Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Keenan Campbell, 432941.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record? You're muted.
Sorry. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit on behalf of Mr. Campbell.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is a better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked, and if I recommend revocation, I'll make a recommendation as to an appropriate sanction. The recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oaths. Mr. Campbell, can you please raise your right hand? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, ma'am.
Thank you. So we're going to go over the procedure for today. So you can put your hand down. Thank you. First, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
So we're going to go over your rights for today. So your first right is that you do have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes, ma'am.
You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, ma'am.
So we're now going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So on charge number 1, the condition of obedience to the law, the charging officer reported that on 12/19/24, you were observed at the First Track bus stop in New Britain. You were observed by New Britain police officers removing a plastic baggie from your jacket pocket that contained a pile of white rock-like substance and handed it to a male in the area. Upon seeing you complete what appeared to be a hand-to-hand drug transaction, New Britain police verbally addressed you to stop walking, and while doing so, you shoved something in your pants, specifically between your buttocks. You deny that you had hid the narcotics in your buttocks, and subsequently a canine search was completed and hit you on your buttocks area. You remained non-compliant during the search and were transported to New Britain Police Department for a strip search to be conducted. You continued to clench your buttocks during the strip search and remained non-compliant until the last time you bent down, and you were informed by New Britain Police Department that they could see the narcotics. The white rock-like substance was field tested and produced a positive results for cocaine. You had 5.2 grams of crack/cocaine on your persons. Subsequently, you were charged with Connecticut General Statute 21A-279A1, possession of controlled substance, 21A-277A1A, sale of narcotic substances, 53A-167A, interfering with an officer, and 53A-155, tampering with physical evidence. You were arraigned in GA-15 on 12/20/2024, and probable cause was found. You have a $90,000 bond and a next court date of 2/14/2025. On charge number 2, the condition of drugs, the charging officer reported that on 12/19/24, you were seen selling narcotics at the Fast Track in New Britain. After your arrest, you were strip searched and 5.2 grams of cocaine were found in your buttocks. Subsequently, you're charged with Connecticut General Statute 21A-27981, possession of controlled substance, 21A-277A1, sale of narcotic substance, 53A-167A, interfering with an officer, and 53A-155, tampering with physical evidence. You were arraigned in GA15 on 12/20/24, and probable cause was found. You have a $90,000 bond and the next court date of 2/14/2025. The state has filed the following exhibits that have been identified for today's purposes as Exhibit A, the parole conditions, Exhibit B, the remand to custody order, Exhibit C, the violation notice of parole, Exhibit D, the parole violation report, Exhibit E, the state of Connecticut judicial branch pending case detail, Exhibit F, the BOPP decision and summary, and Exhibit G, the New Britain PD incident report. In addition, they did file an addendum to the parole violation report on November 13th, 2025, and that states that Mr. Campbell was seen in court, I just want to get the date, on 11/6/2025, and the following happened. You were found guilty of tampering with physical evidence and sentenced to 2 years in jail, and the charges of possession of a controlled substance, sale of narcotic substance, and interfering with an officer were all nollied. So counsel, just to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today.
Yes.
You're able to review them, correct?
Yes.
Thank you. I did receive an exhibit from the defense. I have Exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Counsel, do you need any time to submit any other evidence exhibits?
No.
We do not have any witnesses at this time, so it is now the defense's opportunity to call any witnesses, present evidence, and speak to the charges or any of the evidence submitted. So, counsel?
Yes, thank you. In regards to charge 1 under obedience to the law, I just indicate the addendum is stated accurately, that my client did receive that 2-year sentence. I believe his TS eligibility date on that sentence to be December 19th of this year, with his EOS date to be December 9th of 2026. In regards to charge 2 under drugs, I would just make a note that my client was not convicted of any drug-related offenses in terms of his court appearance on November 6th. Nothing further as to the charges.
Thank you. Just gonna take a moment and I'm gonna announce my findings. So on charge number 1, Mr. Campbell, I am making a finding that you violated the condition of obedience to the law based on your conviction of the tampering with physical evidence on November 6, 2025, when you received that 2-year jail sentence. In addition, the evidence in support of the charge is Exhibits A, D, E, and G. And for charge number 2, I'm also finding that you violated the condition of drugs based on the evidence presented in states Exhibits A, D, and G. So that does conclude the fact-finding portion of today's hearing. Before I make my recommendation, you'll have an opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine the outcome I would recommend. So, counsel?
Yes, thank you. My client is 24 years of age. He's single. He has no children. He does receive his primary support in the community by way of his mother, siblings, 3 sisters, 1 brother, cousins. He's a high school graduate. He did complete in 2022 1 semester of college at 3 Rivers Community College, where he studied marketing as well as English 101. In 2023, he reports obtaining his OSHA 30 certification as well. He was in the community for approximately, I believe, 5 weeks. And this is his first violation of his parole. During the time that he was in the community, he was sponsored to his mother in Hartford. He remained there until his remand. Also during his community supervision, he was able to earn his driving permit. He also obtained employment working at our piece of the pie, doing community work. This was employment he was able to secure immediately upon his release because he participated in an Our Piece of the Pie behind bars program while he was incarcerated. He also attended Our Piece of the Pie doing programming, reentry programming as well. I would note that his parole officer in the recommendation section of his parole violation report does indicate that he was compliant with GPS monitoring. He was always respectful, showed up on time to all reporting sessions. during the time period that he has been within the Department of Corrections, and he has just been recently sentenced, as you're aware, and he's been in custody now for approximately 1 year. So he hasn't had any programming available to him due to the fact that he was an unsentenced prisoner up until just recently. However, he has been attending Muslim religious services during his time period. He's indicating that upon reinstatement to parole, he'd like to be sponsored again to his mother. She was previously his approved sponsor. That address is located within Defense Exhibit 1, and it's in Hartford. By way of education, he is extremely interested in pursuing a career in plumbing. He's interested in enrolling in a plumbing apprenticeship program, either through local 777 or Porter and Chester. He does have his employment to return to, a full-time position at our Piece of the Pie. He's also amenable to any treatment recommendations. We would be asking that he be re-paroled at his TS eligibility date with a MOA. That's the extent of my comments. I'm not sure if Mr. Campbell would like to address you.
Yes, I would like to just take responsibility and accountability for my actions, because I did violate and I did disobey the law while I was in the community. But I wanted to go back out there, re-parole, and work extensively with my parole officer to help me successfully finish special parole and be there with my family and continue to commence into my plumbing passion. That's really it.
Thank you. I appreciate your statement.
Thank you,
Anything
Mr.
further,
Campbell.
council?
No, thank you.
Thank you. I'm just going to take a moment. I'll announce my recommendation. So I have listened to the testimony today. I've reviewed all the evidence submitted. With that, Mr. Campbell, I am going to recommend your parole be revoked. I guess I do want to note a few things. I do recognize this is your first violation on special parole. However, you're only out in the community for, as your counsel said, 5 weeks. Parole's sent over as 48 days. So that's just concerning to me at this point. So I am going to recommend your parole be revoked and that you serve a 2-year period of confinement as a sanction. And that's with a re-parole date of December 19th, 2026. I'm going to recommend the following conditions: behavioral management program for anger management, no contact with victim KS, mental health evaluation treatment as deemed necessary, and I'll note the sponsor for the for your file. In the event the board does lessen my sanction, the MOA stipulation will be added as well. So what happens next, Mr. Campbell, is that your case is going to go in front of the board next week on the 18th. And on that date, the board can do 3 things. They can lessen my recommendation if they choose to do so. They can adopt it if they choose to do so. And if for any reason they would want to see a length of period of confinement longer than what I've recommended, they'll ask you to come back to speak with them and answer their questions and concerns before they impose anything longer. So that does conclude today's hearing. Do you have any questions? No?
No, that's not.
Keenan, you can contact me after December 18th and I can tell you what the board ultimately decided, okay? And then we can talk about that, okay?
Okay.
All right.
Thank you. This concludes the
Thank you.
resolution for Campbell, inmate number 432-941. Thank you, Mr. Jones. Good luck to you, Mr. Campbell.
Thank you.
Thank you. Have a nice day.
You too. Hi, Mr. McClendon.
Bye.
We're gonna get started, okay?
Yes.
Okay, so good morning. My name is Parole Officer Chiselle, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Seville McClendon, inmate number 406118. Today is Thursday, December 11th, 2025, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Robinson Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Seville McClendon, 306118.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Good morning, Peter Matthews with the Public Defender's Office for Mr. McClendon.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I'll review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is a better way to your evidence must establish that, more probably than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked, and if I recommend revocation, I'll make a recommendation as to an appropriate sanction. The recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Ms. McClendon, can you please raise your right hand? You solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury.
Yes.
Thank you. So we're going to go over the procedure for today. So first, you put your hand down. Thanks. I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I'll announce my findings. If you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
We're going to go over your rights for today. So you do have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
You have the right to review the
Yes.
evidence against. Yeah. You also have
Yeah.
the right to. What's happening? Are you good? Do you have a question? Or are you just responding to me
No,
and then I'm going?
no.
And we're just.
It was a little bit lost. I was responding.
It's overlapping. Got it. I think we are a little bit off. I think there's a lag. So just want to make sure I'm not missing anything. All right. So you also have the right to receive the written notice of charge of the violation. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. And you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes.
So we're going to review the charges that the state parole officer has filed or brought against you and the information underlying each charge. I do want to note on the record that a no finding was made for charge number 3 at the preliminary hearing for statutory release criteria. No new evidence has been received from Parole and Community Services for that charge, so it is not going to be taken into consideration at today's hearing. So on charge number 1, the condition of obedience to the law, the charging officer reported that on 7/29/25, you were arrested by the Hartford Police Department for a domestic dispute involving your sister, who for the purpose of this report will be referred to as Jane Doe. You were arrested for punching and then attempting to stab Jane Doe with a kitchen knife after becoming upset about an argument that ensued between yourself and Jane Doe over social media. You're arrested and charged with the following: Connecticut General Statute 53A-182, disorderly conduct, Connecticut General Statute 53A-63, reckless endangerment first, and 53A-61, assault in the third degree. Subsequently, you were in violation of your signed parole condition number 2, obey all laws. Charge number 2, the condition of weapons. The charging officer reported that on 7/29/25, you were arrested by the Hartford Police Department for a domestic dispute involving your sister, for who the purpose of this report is being referred to as Jane Doe. You were arrested for punching and then attempting to stab Jane Doe with a kitchen knife after becoming upset about an argument that ensued between yourself and Jane Doe over social media. You're arrested and charged with the following: Connecticut General Statute 53A-182, disorderly conduct, Connecticut General Statute 53A-63, reckless endangerment first, 53A-61, assault in the third degree. Subsequently, you're in violation of your signed parole condition number 2, obey all laws. The evidence submitted was already identified at the preliminary hearing, so that all does remain the same. In addition, Parole and Community Services did file an addendum to the parole violation report that reads on November 19th, 2025. And that states that you were seen in court for the charges. They went,
It didn't have a date
did not have a date.
in the report. I
And tried.
do have it somewhere, not right in front of me.
Mr. McClellan, do you remember when you were in court for that case by any chance? What day?
When I did the last day, I believe it was the last day I went to court was the 18th of,
The 18th of November?
yeah. No,
Okay.
Yes,
October.
that's correct. November 18th.
November 18th? November 18th.
Yes,
Okay, so we'll go with, so on November 18th, you did appear in court. And it states that all of the charges, which were reckless endangerment, disorderly conduct, and assault, were all nollied. You were sentenced on a violation of probation charge that stemmed from the arrest and were sentenced to 6 months. Your EOS is 3/11/26, and you do not have any pending charges at this time. Counsel, just to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes, we did.
Thank you. And I did receive exhibits from the defense. I have exhibit 1, a list of parole accomplishments and future plans for parole reinstatement, as well as exhibit 2, the statement from Herbert Clendon, who's the uncle, correct?
That's correct.
Do you need any time to submit any additional?
I do not know.
We don't have any witnesses, so it is now the defense's opportunity to call any witnesses, present evidence, and speak to any of the charges or the evidence submitted. So counsel?
Thank you. As was indicated, the criminal charges, which were the basis for charge 22, they were both nollied in Hartford Court back in November. Mr. McClendon always very strongly challenged the statements that were provided by his sister regarding this incident. Presumably, the prosecutor did review these allegations and reviewed the evidence, and after taking everything into account, they elected not to pursue the case. I acknowledge reading the initial reports, it sounds like it was a serious incident, but I would ask you to consider the fact that it was not pursued. I know his uncle gave a very different version of what happened. Mr. McClendon gives a very different version of what happened. They indicated that his sister was hitting him on the head with both the 2 cell phones. And it sounds from that statement that she was the primary aggressor in this incident. I know there's been some history of animosity between the 2 parties. And Mr. McClendon did indicate he was just trying to protect himself from his sister, who was very angry and out of control at the time. So after reviewing everything, the state elected not to pursue any of these criminal charges. He did enter admission to a VOC, however, he didn't plead guilty to any of the domestic charges, which were the basis of this violation. This isolated incident was the sole basis for the violation. Other than that, it appears he was doing well with regard to his parole. So if there is a finding on any of these 2 charges, I would like to be heard further. Thank you.
Thank you. Take a moment and I will announce my findings. So I do understand, Mr. McClendon, that the charges were nollied in court, but that does not negate that behavior actually occurred for that. So with that, I am going to make a finding on charge number 1, the condition of obedience to the law based on the evidence presented in the state's exhibits C, D, E, and G, as well as defense exhibit 2. And I'm also going to make a finding of probable cause. Sorry, it's not probable cause. It's a different hearing. I'm making a finding that you violated the conditions. Did that one? This one's wrong. Sorry, I'm making a finding that you did violate the condition of weapon. Based on the evidence presented in states exhibits C, D, E, as well as defense exhibit 2. So with that, it does conclude the fact-finding portion of this hearing. Before I make my recommendation, you'll have an opportunity to speak to your background and history. The purpose of this part of the revocation is to help determine what outcome I would recommend. So counsel?
Thank you. So Mr. McClendon, he's 39 years old. He was born and raised in Hartford with his family. He still has a lot of family in the Hartford area, including his 2 children, who are 13 and 5. His daughter, she's autistic and nonverbal, and he does take a very active role in caring for her, along with both him and his mother do. And he has a very good and cooperative relationship with his daughter's mother in caring for their child. He also has a very close relationship to his younger sister, who has been undergoing a lot of medical issues that Mr. McClendon is hopeful to continue helping her with when he is released. I know based upon this, there may have been some issues with his other sister, but generally, Mr. McClendon has a good and supportive relationship with most of his family in the Connecticut area. So Prior to his remand, Mr. McClendon was residing in a Reach House. He'd been there for about 6 months. Before the Reach House, he was in the Open Hearth Halfway House program. He did successfully complete the Open Hearth treatment program at that halfway house. He had been successful in multiple halfway house programs over the course of his parole. When he is released, Mr. McClendon is asking to be placed in the Hartford area. Prior to his remand, he was working. He was working at Denny's on Flatbush Avenue. He'd been there for about 7 months. He did have a very good relationship with his employer. He's hoping he'll be able to get that job back when he is released. He has procured a lot of positions over the past few years with temp agencies as well. The mitigation report he submitted does go through some of his work history, and he's always been good about finding work in a fairly quick manner. He's a hardworking man and does want to get back to work when he's released. He graduated from high school. He did obtain an associate's degree at Manchester Community College. He did recently start additional classes at Capital Community College, and he is also interested in continuing to pursue this program as well when he gets out. So he was last released from incarceration in October of 2024. He'd been under supervision for about 9 months at the time of the remand. During this period of time, the only other noted misconduct was there's one occasion where he returned a little late to the halfway house. Other than that, he was doing very well with his parole supervision. It seems he's been cooperative with parole during this period of time. He was engaging in mental health treatment through CRT. At the CRT program, he had done an IOP program, he had done group therapy, and he had done individual cognitive therapy. There's no noted positive urinalysis tests over this period of supervision. And as I indicated, he cooperated with the halfway house placement and the program there as well. So he's been very cooperative with all the treatment that's been set up for him by parole over this period of time. I know that PBR recommends that he continues with mental health treatment when he's released, and he's certainly willing to do that. He is apologetic about the incident with his sister. As I indicated, he disputes her version of events. And based upon the state's decision not to prosecute, I suspect they had some questions about her version of events as well. But he does acknowledge that it was an unfortunate incident that he probably could have handled a little bit differently. All the charges are misdemeanor in nature. There's no allegation of any felony conduct. And as I indicated, other than this, he was doing very well in supervision. I know Mr. McClendon has had a few prior violations, but I don't think his conduct in this incident is such to provide evidence that he's unwilling or unable to work with parole and cooperate with supervision. I think he is willing and able to cooperate with supervision going forward. He has a plan. He knows he needs to engage with mental health counseling. He knows he needs to get back to work, and he's planning on doing that. The recommendation from parole was a sanction of 6 months to 1 year. Given the outcome in court and everything else he's been doing, I would ask you to consider a 6-month sanction in this case, as opposed to a longer recommendation of 1 year. Given that the charges were not being pursued, I think that would be appropriate to put it on the lower end of the sanction that was recommended. He has been incarcerated for a few months now, and he is anxious to get back out there to see his family, to help with his daughter, and get back to work. Mr. McClendon, is there anything you'd like to add at this point in time?
No, other than my sister attacked me. I understand the situation in that, but I was attacked by my sister. Like I told y'all before, my younger sister had a heart attack. So all my sisters put a conservative for me to be in charge of my younger sister. We were supposed to go August 5th. You feel me? My other sister was stealing my sister because he lost brain activity. So my sister and my grandmother was stealing their money. My brothers and sisters put a conservative for me to be charged with my sister while she in her state because she can't move or she lost brain function. They purposely knew I was on special parole and they called the cops on me and lied to me so I won't make it to the conservatives on August 5th. You feel me? As my uncle stated, he was there, he was a witness, she was attacking me. I was just trying to get away. I was blocked from leaving the house. You feel me? I'm apologetic about the role I played and having a police contact, but this time around, I really didn't do nothing. I really tried to do the right thing, and I was punished for it. You feel me? Because they ain't want me to go to the conservative. That's all I want to say.
Thank you, Ms. McClendon. I do appreciate your statement. Counsel, anything further?
No, anything else to add?
Just gonna take a moment. I have listened to all the testimony presented today. I have reviewed all the evidence presented as well, Mr. McClendon. With that, I am going to recommend that your parole be revoked and that you serve an approximate 6-month period of confinement as a sanction, and that's with a reparole date of January 29th, 2026. I'm going to make a recommendation for the following conditions: behavioral management program for anger management, no contact with victim OL, no general no contact with LM, a general no contact with DM without your parole officer's permission, a mental health evaluation and treatment as deemed necessary, no operation of a motor vehicle without parole officer's permission, and halfway house placement in Hartford. I just want to reiterate that, Mr. London, do not have contact with your sister unless you ask permission first, okay? Speak to your officer if you need to be around her or with her, whatever the case may be, okay?
Yes.
Just don't get yourself locked up with that one, okay? I didn't mean that.
Yes.
I just meant don't get yourself in trouble by doing that, okay? If the board accepts the recommendation, but I just want to make it known since I know you are family, but just be mindful, okay? So what
Yes.
happens next, Mr. McClendon, is my recommendation is going to go to the board. Actually, I think I need a MOA, right? He has that VOP coming. Yeah,
So it's not pending anymore, right?
it's running though until March. So I'm also going to do a MOA stipulation. What that means that is if the board adopts my recommendation, that gives DOC the right to like look at you for early release for that sentence if they choose to do so. If not, you could be in
Yes.
for it, but it's up to DOC, okay?
Yes.
So I'll do a MOA recommendation as well, stipulation as well. So what happens is my recommendation is going to go to the board next week on December 18th. On that day, the board's can do a few things. They can adopt my recommendation if they choose to do so. They can lessen it if they choose to do so. And if for any reason they would want to see a period of confinement longer than what I'm recommending, you'll be asked to come back and talk to them and answer their questions, concerns before anything longer is imposed, okay?
Yes, ma'am.
Do you have any questions? Did I confuse you about that, like, MOA stipulation thing? Because I probably confused myself a little. You understand
No,
that?
no, you didn't. Yes.
You're good?
Okay, so
Yeah.
any questions you can call, okay?
All right. I got one question. Can you see if when I'm placed in the halfway house, can it be on like the south end of Hartford instead of the north end?
I don't have any control over that. Whoever you're reporting to, Parole and Community Services does housing placements. I can note it in the report that I'm gonna write, but it is ultimately up to them, and it's not even guaranteed you'll be in Hartford. They place you where their location if they have to release you. So I'll make note of it, but once you're out, maybe just try to work with them. If it's not the right place for you, just try to be compliant, work with them the best you can to get to where you need to be, okay?
All right, thank you.
All right, thank you, Mr. McClendon. Good luck to you. This concludes the revocation
you
hearing
too.
for Seville McClendon, inmate number 306118. Thank you.
All right. Have a nice day.
Okay.
All right, we're making progress so we can see Gardner now. Officer Grant, can you just confirm your video is working so that we can see you? Perfect. All right, I think we did it. I think it's working now. So we're gonna get started. I don't want to jinx anything. Good morning, Mr. Gardner. We're gonna get started really quick right now, okay?
Good morning.
So good morning. I am Parole Officer Tricello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Jimmy Gardner, inmate number 200386. Today is Thursday, December 11, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Brooklyn Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Jimmy Gardner, 200-386.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Sure. Attorney Alfonso Sorico from the Parole Revocation Unit on behalf of Mr. Gardner this morning.
Thank you. And also as your charging officer, can you please identify yourself for the record?
Oh, Jimmy Garner.
You're good, Mr. Gardner. Sorry, Officer
Oh.
Grant.
Parole Officer Lisa Grant, State of Connecticut, Department of DOC, Parole and Community Services.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I'll review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is a better or weaker evidence must establish that more probably than not the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked. And if I recommend a revocation, I'll make a recommendation as to an appropriate sanction. The recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can't be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Gardner and Officer Grant, can you both please raise your right hands? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury.
True. Yes.
Thank you, Mr. Gardner. I can't hear her. Oh, you were muted. I'm like, oh, I just figured there was a lag.
No, I can't hear, but it jumped a little bit.
Yeah. All right, so we're gonna go over the procedure for today. So first I'm gonna read you your rights. Then we're gonna review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will then have an opportunity to present all relevant testimony, subject to cross-examination, and any relevant documents. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings. And if I find you have violated one or more of the conditions of your parole, the state will have an opportunity to speak to your background and history. And after the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
You talking to me?
Yeah, sorry, Mr. Gardner. Yeah, do you have any questions about the purpose or procedure?
No. No.
I didn't explain it to him.
Okay, all right, perfect. So we're just gonna go over your rights for the hearing today. So you do have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
He did.
Perfect.
Yes.
Thank you. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
Thanks. So we're now going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. Officer Grant, can you please review the charges for us? And you are muted. Perfect. Thank you.
Okay. Charge number 1, absconder. On April 1st, 2025, you went to Chase Center's halfway house's front office to sign out for work. Staff informed you that you didn't have a pass and asked you to provide a work schedule in order for the on-call duty officer to give permission to create a pass. You told staff to review previous passes to verify your schedule. Staff told you that you could not provide a pass, that they could not provide a pass based off previous passes. You then asked, how were you going to show a schedule, and stated that you've been left the halfway house to go to work. You stated then your people would get your stuff. At 5:58 a.m., you proceeded to walk out of the front door without permission from halfway house staff. This parole officer Grant called you and instructed you to return to the halfway house ASAP so that staff could contact the job to verify the schedule. You stated you were frustrated with halfway house but agreed to return, but never did. At 7:30 a.m., PO was notified that you had not returned to the halfway house. Staff contacted St. Mary's Hospital, Waterbury Hospital, and checked Waterbury Police Station in an attempt to locate you, to no avail. Staff attempted to call your job and was sent to voicemail. Area Program Director Luis Rodriguez and job developer Ruben Rivera went to Global Steering Systems to verify if you were at work. The APD spoke with Christina from HR and Stephanie from the temp agency Randstad. At 11:45 a.m., Stephanie stated that you had perfect attendance until this week. Stephanie stated that you did not report to work. You walked out of your only parole-approved residence at Chase Center Halfway House located at 21 Cliff Street in Waterbury without permission from Halfway House staff or parole. On 4/1/25, 4/7/25, and 4/16/25, parole instructed you to turn yourself in. You failed to comply and had made no efforts to disclose your location. On 4/23/25, parole conducted a community search for you in the Waterbury area and was unable to locate you. Your whereabouts in the community remain unknown. Your actions violated your conditions of parole, specifically release directions. I will live in a residence approved by my parole officer. Charge number 2, obedience to the law. On 9/24/25, you were arrested by Waterbury Police Department for interfering. Charge number 3, drugs. On or about 3/21/25, you used cocaine. Charge number 4, halfway house placement. On 4/1/25, you went to Chase Center Halfway House's front office to sign out for work. Staff informed you that you didn't have a pass and asked you to provide a work schedule in order for the on-call duty officer to give permission to create a pass. You told staff to review previous passes to verify your schedule. Staff told you that you cannot provide they could not provide a pass based off previous passes. You then asked, how are you going to show a schedule, and stated that you should have been left the halfway house to go to work. You then stated your people would get your stuff. At 5:58 a.m., you proceeded to walk out the front door without permission from halfway house staff. The parole officer, Grant, called you and instructed you to return to the halfway house ASAP so that staff could contact the job to verify your schedule. You stated you were frustrated with halfway house, but agreed to return, but never did. At 7:30 a.m., this PO was notified that you had not returned to the halfway house. Staff contacted St. Mary's Hospital, Waterbury Hospital, and checked the Waterbury Police Station in an attempt to locate you, to no avail. Staff attempted to call your job and was sent to voicemail. The area Program Director Luis Rodriguez and job developer Ruben Rivera went to Global Steering Systems to verify if you were at work. Area Program Director spoke with Christina from HR and Stephanie from the temp agency Randstad. At 11:45 a.m., Stephanie stated that you had perfect attendance until this week. Stephanie stated that you did not report to work. You walked out of your only parole-approved residence at Chase Center Halfway House, located at 21 Cliff Street in Waterbury, without permission from Halfway House staff or parole. On April 1st, 2025, on April 7th, 2025, and April 16th, 2025, parole instructed you to turn yourself in. You failed to comply and had made no efforts to disclose your location. On April 23rd, 25, parole conducted a community search for you in the Waterbury area and was unable to locate you. Your whereabouts in the community remained unknown. Your actions violated the halfway house agreement. Specifically, I will not leave the physical confines of the halfway house unless authorized by program staff or parole.
Thank you. You've also submitted evidence in support of the case. Can you please identify the evidence for today's hearing?
So,
No, not you, Jimmy.
Oh, okay. Can you give me a minute to get the list?
Sure. If not, do have it in front of me. I can.
I have no objection to having the hearing examiner read it. I have a
Review
copy.
it today. So it's Exhibit A, the remand to actual custody. Exhibit B, the parole violation report. Exhibit C, the PCS signed conditions. Exhibit D, the halfway house agreement. Exhibit E, the residential discipline report dated 3/31/25. Exhibit F, the Redwood toxicology laboratory report dated 3/31/25. Exhibit G, the PCS incident report dated 4/1/25. Exhibit H, the revocation hearing summary. Exhibit I, the substance abuse referral screening form. Exhibit J, the notice of parole violation. Exhibit K, the notice of parole rights. And Exhibit L, the Waterbury Police Department incident report 250093584. You did also file addendums to the parole violation report. Do you have those available, or would you like me to review them? Officer.
Please review them.
Yeah, no problem. So we have the first one is was submitted on September 29th, 2025. And that states that on 5/28/25, the Board of Parole issued a warrant based on the report declaring the offender an absconded from special parole supervision. And that on 9/24/25, Gardner was arrested and was apprehended by the Waterbury Police Department for interfering as well as an absconder. Then the second one was submitted on 11/17/25, and that states that on 11/6/25, under docket number ending in 629S, Jimmy Gardner did not enter a plea for interfering with an officer, and he received a nollie. Counsel, to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents for today.
Yes, we did.
Thank you. And I did receive exhibits from the defense. I have Exhibit 1, a list of parole accomplishments and future plans for parole reinstatement, as well as Exhibit 2, the certificates numbers 1-16. Counsel, do you need time to submit any other evidence?
No.
Okay, we do not have any witnesses at this time, so it is now the state's opportunity to call any witnesses, present evidence, and speak to any of the evidence submitted. So Officer Grant, would you like to make any comments towards the charges?
So Jimmy Gardner discharged to special parole to Chase Center Halfway House initially on 7/18/2019. On 9/23/19, he transferred from the halfway house to community supervision. During that supervision period, he received 16 misconducts for mostly positive drug screenings and GPS
Officer
violation.
Officer Grant, I'm gonna quickly stop you. So right now, we're just speaking towards the charges. If the hearing moves on to the second part, for the aggravating information, all of that's there. So anything direct towards the charges of obstruction of obedience to the law, drugs, or halfway house placement?
That is it for those charges.
Nothing towards the charges? Okay, thank you. And counsel?
Just briefly, P.O. Grant, have you been supervising Mr. Gardner on this supervision, which started on October 13th of 2023? Have you been with him since day one, or was he transferred to you as something?
I'm sorry, it's a bad connection. I didn't hear your entire question.
Have you been supervising Mr. Gardner since October 13th of 2023?
Yes. Well, I supervised him, I supervised him when he came to Chase Halfway House April 1st, 2025.
Okay. So you have not been his parole officer since his release on October 13th of 2023. Is that correct?
No. Okay.
And according to the exhibit B, under the graduated interventions and sanctions, It appears, according to this document, there had been no issues within the past 6 months.
With, excuse me, can you repeat that? There hasn't been any issues within the past 6 months with his signed conditions? Is that what you're asking me?
Yes, going by Exhibit B, which is the parole violation report, for the fugitive, that in the page 2, under graduated interventions and sanctions, it indicated none within the past 6 months.
No, his only charge started, well, his charges started on March 31st. He had a positive drug toxic screen, which he would have been given a misconduct for, but on April 1st, he walked out of the halfway house.
Correct. Okay,
Therefore, he wasn't able, therefore, I wasn't able to issue him a misconduct because he had absconded at that point.
Understood. Right. Mr. Gardner, this is a question for you.
Yes, sir.
Prior to April 1st, the day the allegation where you left the Chase Halfway House Center, had you been working, so from April 1st going backwards, had you been working at the same location for a while?
Yes, for almost 2 months.
Okay, and within that 2 months, the work passes from the halfway house, were they for the same hours? Did you have the same
Yes.
schedule for those 2 months?
Repeatedly,
Okay.
yes, repeatedly.
Okay, and what were your hours?
7 to, like, it started at 7 o'clock, 8 hours from then. So
Like
it's about-
7 a.m. or p.m.?
Yes, so, yeah, because we gotta catch the bus. I leave at 5, we go catch the bus, probably be at work by like 6:30, 7 o'clock, something like that. And we stay about 8 hours to work.
Okay, and when you were given those work passes, was it a daily pass or were you given a pass for the week or
The
2
pass
weeks?
for the
How?
The whole month, supposed to be in there the whole month. And I sat down with Mrs. Grant, the supervisor of the halfway house, on March 31st, because they kept me back already at March 30th. So March 31st, I sat down with Grant and all of them, explaining the unstableness of me making it to work. You know, the passes don't be here, we put them in, they don't be on their job. So I'm trying to straighten that out with them. So now the next day, because I went out to a pass that same day, the 31st, you know? So then the next day I go to work, they say I don't got a pass, and I said, how? I just sat down and talked to them, everything should be smooth, you know? So I said, call the parole officer, they said they can't do that. Call the supervisor, they said they can't do that. They call on-call, they're talking about a work schedule. Y'all got a copy of the work schedule before you get a job, you gotta bring the work schedule. So that was 2 months ago, so you've been at the work schedule, it didn't change.
Understood, and that was my question. So you made an attempt, I believe you said March 30th, to try to straighten this out with the parole officer and the supervisor, correct?
Yes, yes.
Okay, and then according to the, when they contacted your employee, it looked like you had perfect attendance up until March 31st. Is that correct?
Yes, March 30th, 31st, and April 1st. I called when I left out. You know, I was catching the bus up there. They said, your position had been taken. They did no more. So that's the third day I missed, you know, going to work late, whatever the case may be. So I just,
Okay.
I was frustrated and relapsed.
Okay, and you beat me to my next question. Is it a fair statement, starting March 31st / April 1st? Well, April 1st, that morning is when you got frustrated because of the work situation, correct?
Yes, sir.
And then you relapsed,
Yes, sir.
correct?
Yes,
All
sir.
right. And then you were picked up by the Waterbury police on September 24th of 2025, correct?
Yes, sir. Yes, sir.
Okay, in that case, those charges were nollied in court on November 6th of 2025, correct?
Yes, sir.
All right, and my last question, during that period of time from April 1st to September 24th, 2025. You were in the state of Connecticut that entire time, correct?
Old time. In
Okay.
Waterbury.
Okay, I don't have any further questions of either of them. I just wanted to give you a little background as to what occurred. We're not disputing what P.O. Grant said about my client leaving the halfway house on April 1st, but it's important to know why he left. Obviously, the relapse was one of the issues, and the other issue was it appears he had a perfect attendance according to when they called his job up until the 31st. As he indicated, he's had the same hours for the past 2 months. It's not like he worked the morning shift, afternoon shift, or overnight shift. So he was under the impression that he was good to go on April 1st. I understand the better way of handling the way he did, but I just wanted to give you a little background regarding his work schedule. I don't have any other comments regarding the first part of the hearing. I know charge number 4 on the halfway house claim, it's the same language that's used in charge number 1, so that would be my same comments for that. I don't need to repeat all those again. Thank you.
Thank you. Just want to confirm any additional comments from either side. Officer Grant, anything additional at this time? Towards the charges?
Just one comment about the passes. He's fully aware that with the halfway house, the passes for the work schedule has to be submitted each week. If they're not submitted within 3 business days prior to the beginning of the week, passes cannot be approved. So at that point, we were willing to work with him to get passes approved. Staff is responsible for providing a weekly employment verification with the job, and they cross-reference it with his schedule, with his pay stub, and then also contacting the employer to verify attendance and also the current week's schedule. I just wanted to note that.
And my just comment on that, I'm not disputing what you're saying, P.O. Grant, but if that's the case, and correct me if I'm wrong here, March 31st was a Monday of 2025. So he did go to work on that date. April 1st is a Tuesday. Why would he only have a pass for Monday and not Tuesday if the pass is a weekly pass? Can you help me out with that?
I don't know if he submitted it or not.
Okay.
So he's responsible for providing his passes.
Okay, based on, I understand it's a weekly pass, but the issue I'm looking at here is the 31st is a Monday and April 1st is a Tuesday. So a little confused as to why the pass would start on a Tuesday and not on a Monday and go from Monday to Friday. That's all I'm saying. I'm not disputing your comments regarding the weekly pass, but looking at the calendar, in Monday is March 31st. Tuesday's April 1st. He was allowed to go to work on Monday with a pass, but then a new pass would start on a Tuesday. I don't have anything further to say. Thank you.
All right, I'm just gonna take a moment. I'll announce my finding. So on charge number 1, Mr. Gardner, I am making a finding that you violated the condition of absconder based on state's exhibits B, C, and G. On charge number 2, although the court did not lay that case, it doesn't negate that the behavior occurred. So I'm also making a finding that you violated the condition of obedience to the law based on the evidence presented in state's exhibits B, C, and L. On charge number 3, the condition of drugs, I'm also making a finding that you violated that condition based on state's exhibits B, C, E, and F. And on charge number 4, I found that you violated the condition of halfway house placement based on the evidence presented in state's exhibits B, C, D, and G. So that does conclude the fact-finding portion of this hearing. Before I make my recommendation, the state will have an opportunity to speak to your background and history. And after the state is finished, you'll have the same opportunity. The purpose of this part of the revocation hearing is to help determine what outcome I recommend. So Officer Grant, would you like to make any comments towards Mr. Gardner's background and history, please, at this time?
Yes. So Gardner initially was discharged to special parole and on 7/18 2019 and went to Chase Halfway House. He then transferred from the halfway house to the community. Within that supervision period, he received 16 misconducts, mostly for positive drug screenings and GPS violations. He subsequently received a 3-month sanction from BOPP when he was remanded then. Being that he walked out of Chase Center Halfway House on April 1st of 2025 and admitted to using drugs, and which placed him at a high risk of overdosing and failure to contact parole to make his location known, and also failure to return back to parole supervision. I'm requesting that his special parole be revoked for a minimum of a year, with hopes that when he returns to the community, that he continues with mental health treatment, no alcohol consumption, a substance abuse treatment program, and halfway house placement if he does not have a viable sponsor.
Thank you. Counsel?
Yes, on behalf of Mr. Client, if I may address Peel Grant's comments, I'm not disputing what she put on the record, but she previously indicated she did not start supervising my client up until this incident here. He was sanctioned to the 3 months on his previous violation. I'm not disputing that. But after that, after he was sanctioned and after he was re-paroled, he, on January 18th of 2024, which is prior to Peel Grant supervising my client, he was transferred to the App Foundation for Inpatient Substance Abuse. And it appears, this is from the narrative that the parole officer wrote, on 2/16, he was successfully discharged from the App Foundation to the Chase Center. So he did address his issues and he did do some treatment. My client is 51 years old. He does have 3 children. He has his children, all adult children. Unfortunately, one of his sons was actually murdered in Hartford on September 14th of 2022. And while on supervision, Mr. Gardner was placed in a hotel for a period of time because the building he was living in caught on fire. So he's had some things in his life. I'm not making excuses for him. He's 51 years old. He does need to get the substance abuse issue under control, but he's on supervision until 2028. Upon his previous release, it looks like October to January, he was at the Connecticut Renaissance Halfway House in Waterbury, where he did successfully complete the App Foundation. As I indicated, then he was at the Community Solutions Halfway House in Waterbury. And then he did self-sponsor in Waterbury, as I indicated. Unfortunately, that building he was living in caught fire and he was placed in a hotel. He did graduate from high school. He's indicated to us in 2007. He did complete some sociology courses while incarcerated at Chester Correctional Institution in sociology, and also obtained various certifications from the American Job Center. Those certificates that we submitted are all dated 2024, 2025. So they are recent certificates that Mr. Gardner was involved in numerous programs to try to increase his work background. So he has been doing numerous things, and I indicated I don't need to read all of those, but we did submit them all. He did provide them to us. He was working full-time at Global Steering, as he indicated, for approximately 2 months prior to his remand. It was a full-time job, as he indicated, and previously he did utilize Steadfast Staffing Solutions in Waterbury, and he was placed at numerous job sites around the state. Also, upon his release, it looks like in 2019, he did voluntarily attend individual therapy with Ms. Realbo, initially virtually and then via video due to the COVID-19. He did participate in a domestic violence program, did receive clinical services from Wellmore, in Waterbury and needed IOP at Connecticut Renaissance. So my client has been engaged in treatment, not disputing it. He self-admitted that he did relapse March 31st / April 1st. He is amenable. He does want to be put in a halfway house in Waterbury. I know P.O. Grant had indicated that also, unless he had a Bible sponsor, he did not provide one to us. So he's looking for a halfway house in Waterbury. And some point down the road, after he's in compliance with that, he'd like to obtain an independent residence, as he previously had indicated to us. He can return to his job at American Job Center in Waterbury. And he does want to complete requirements to become a recovery coach through Connecticut Community Addiction Recovery, CCAR. And he's amenable to any opportunities in the community, whether it's to do a treatment and or work related. He did obtain his driver's permit. He's indicated to us this first time he's had it. And he does want to obtain his actual driver's license. Mr. Gardner, anything I left out about your background or what you want to do when you get out? If you want to add anything, it's not your opportunity. You can't discuss the first part of the hearings as to what you were violated for. Just about your background. Is there anything you want to add?
Yeah, I know I just thought I'd go out there get back right what I was doing, you know, and I was going through a hard time, you know, for a couple of years. So now, like, I really cleared up a little bit. I was out. It felt like I was free from the 5 months because I was stressed out in 26 years, and I've been in halfway house for 4 years, and I was in the Chase Center before 2 years, and then they brought me back over there. Like, and see, I'd be getting stuck in Chase Center. Anywhere else, I'm straight. You know what I'm saying? I can't really get a good job because I ain't gonna be able to be obligated to it because I'm gonna be missing days, you know, in the halfway house. You know, as long as if everything on the same page, everything working together, I could stay working and get my money saved up and get an apartment and get back where I was at, you know?
Thank you for coming.
Thank you. I appreciate your comment, Mr. Gardner. Any additional comments from either side?
I don't have anything else to add.
Officer Grant, any additional comments?
No.
Okay, thank you. So I'll just take a moment and announce my recommendation. Okay, so I have listened to all the testimony today. I've reviewed all the evidence presented with that. I do want to note a few things on the record. This is Mr. Gardner's second violation of special parole, as stated, and he did receive a 3-month sanction for that last one. However, he appeared to be in the community for approximately 1.5 years in between his re-release and remand. With that, the evidence does state that he had perfect attendance at his job, so he was doing, I think it sounds pretty well, leading up to the day he left the halfway house, unfortunately. And I did review all of the training certificates. So I'm impressed. You did a lot in the community, Mr. Gardner. However, you were gone and unaccounted for about 6 months. So that's just a little bit concerning. But with all those all that information, I am going to recommend your parole be revoked, Mr. Gardner, and that you serve an approximate 4-month period of confinement as a sanction. That's with the re-parole date of January 25th, 2026. I'm going to recommend this following conditions: no consumption of alcoholic beverages, behavioral management program for domestic violence, no contact with co-defendant Hassan Allen, mental health evaluation and treatment as deemed necessary, and a halfway house placement in Waterbury. So what happens next, Mr. Gardner, is my recommendation is going to go to the board next week on the 18th. On that date, the board can do a few things. That they can lessen my recommendation if they choose to do so. They can adopt it if they want to. And if for any reason they would want to see a period of confinement longer than what I'm recommending, they will ask you to come back for another hearing to address their questions and concerns, but for anything longer is imposed. Do you have any questions right now, Mr. Gardner?
No, not right now.
Okay.
All right, so Mr. Gardner, it's going to the board on the 18th. You and I will get a written report, and I believe the parole officer also about a week later with the final outcome. If they adopt the recommendation, January 25th of 26 is your release date. If they want to give you additional time, another hearing. If there's an issue with them not adopting it, I'll set up a legal call with you and I'll go over the next step with you if I need to, okay?
Okay, sir.
All right, good luck to you.
Thank you.
Thank you, Pio Grant.
This concludes the revocation hearing for Jimmy Gardner, inmate number 200386. Thank you. Good luck to you, Mr. Gardner.
Thank you. Bless. Sure.
You're all set. Take care.
You too now.
He has to go to lieutenant's office.
Thank you. We need Officer Bennick. Officer Bennick, are you with us?
I'm here.
Thank you. And just, I did see you, Officer Barrios, just to put it out there, we're running behind. We had a whole internet outage, so we're way behind at this point, unfortunately. Not way behind. We'll get to you soon, hopefully. Okay, Officer Barrios, we're gonna try to catch up, even though it won't happen, but we're gonna try. You hear? Good. All right, we're gonna get started. Okay, Mr. Brown?
Is my lawyer here?
He is.
Right here.
You see him?
I see him. All right.
All right, we're gonna get started. So good morning, I'm Parole Officer Tricello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Kenneth Brown, inmate number 326008. Today is Thursday, November 11th, 2025, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Cheshire Correctional Institution. Can you please state your full name and DOC inmate number for the record?
My name is Kenneth Brown, inmate number 326008.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself? For the
Sure. Attorney Alfonso Sorico with the Parole Revocation Unit on behalf of Mr. Brown.
Thank you. And also present is your charging officer. Can you please identify yourself for the record?
Sure. Parole Officer Bethany Bennick with the Mental Health Unit for Parole and Community Services.
Thank you. So this is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe that you violated one or more of the conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Brown, can you please raise your right hand, and Officer Bennick as well? Thank you. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the full truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes.
Thank you. Yeah,
Yes.
just perfect. Thanks. So we're going to go over the procedure for today's hearing. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will then have an opportunity to address the issue of probable cause and the severity of the allegations. And after the state is finished, you will have the same opportunity. At the conclusion of this hearing, I will inform you of my findings, which will be based upon the available evidence. Do you have any questions about the purpose or procedure before we begin?
Yes, actually I do.
Okay.
I filed a suit against her, against my parole officer. And I don't even honestly, I was told that she wasn't supposed to be here. Somebody else was supposed to be taking her place. I have a pre-allegation against her. And I also have a theft case against her. So I'm not understanding why she's here. Shouldn't I have somebody else present?
Pio Trucello, I can speak to that if you want the response to that.
Sure.
Okay, I did contact the PREA unit and spoke with the captain. He said because this is in the scope of my normal jobs and what we would normally doing, I am permitted to participate in this hearing. As far as the suit with the property, I have no idea what he's talking about.
So Kenneth, as I advised you regarding the theft issue, that's something that needs to be taken care of after this hearing is resolved. But you can, this is not part of this violation. I did advise you of that via telephone. And as far as what the other claims, she just put on the record, she was advised she can be here. If you want to do something about it after the hearing, you can. It's not part of this course of what I'm representing you on here for these alleged violations. Do you understand that?
All right.
Okay, thank you, P.O. Bennett, for clarifying that.
Thank you as well. So with that, we are going to keep moving forward with today's hearing, as planned and scheduled, okay? So we're going to go over your rights now, Mr. Brown. So you do have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes, I did.
Perfect. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand all these rights, and are you ready to move forward?
Yes, I understand.
Perfect. We are going to now review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. Officer Bennett, can you please review the charges that you have brought against Mr. Brown?
Yep. On 10/21/25, you were unsuccessfully discharged and formally banned from the Connecticut Community for Addiction Recovery Program. On 10/20/25, you assaulted another resident at Walter Brooks Halfway House. You intentionally punched the resident as well as used a chair and milk cartons as weapons, thereby recklessly creating a risk. These behaviors meet the criteria for Connecticut General Statute 53A-182 disorderly conduct. On 9/16/25, you rendered a urine specimen that was positive for phencyclidine. This specimen was sent to Redwood Toxicology Labs and returned as confirmed positive on 10/1/25. On 9/1/25, you rendered a urine specimen that was positive for THC and amphetamines. The sample was confirmed by Redwood Toxicology Labs and returned positive for THC and amphetamines on 9/10/25. On 5/8/25, you rendered a urine specimen that was positive for cocaine. The specimen was sent to Redwood Toxicology Labs and returned as confirmed positive on 5/13/25. On 10/21/25, you refused to allow your parole officer to search your phone, which was under your possession, by refusing to give her your unlock code as instructed. On 10/20/25, you assaulted another resident at Walter Brooks Halfway House. You punched the resident as well as used a chair and milk cartons as weapons. This is in violation of your signed halfway house agreement. Specifically, I will treat others with respect and not engage in verbal or physical altercations with other offenders, staff, or third parties. On 10/19/25, you sent the program director of Walter Brooks Halfway House a harassing, vulgar, and racist text message. This is in violation of your signed halfway house agreement. Specifically, I will treat others with respect and not engage in verbal or physical altercations with other offenders, staff, or third parties. On 9/1/25, you told Walter Brooks Halfway House that you were going to CCAR and left the house from 10 a.m. until returning at 5 p.m. When the staff called to confirm this, they learned that CCAR was closed that day, leaving you unaccounted for in the community for approximately 7 hours. This is in violation of your signed halfway house agreement. Specifically, I will not leave the physical confines of the halfway house unless authorized by the program staff. I will only go to locations indicated on an approved community pass unless changes have been authorized by staff. On 4/8/25, at 4:25, you requested a community pass to attend a dental appointment. When staff called to confirm the appointment, the dental group denied having any appointments for you, nor did they accept your insurance. This is in violation of your signed halfway house agreement. Specifically, I will not leave the physical confines of the halfway house unless authorized by the program staff or parole. I will only go to locations indicated on an approved community pass unless changes have been authorized by staff.
Thank you. And you've also submitted evidence in support of the case. Can you please identify the evidence for us?
Yep, let me just. Okay. Exhibit A, signed conditions of parole. Exhibit B, remand to actual custody order. Exhibit C, signed notice of parole violation with rights. Exhibit D, parole violation report. Exhibit E, email from Walter Brooks House Program Director, Parks forwarded discharge from CCAR, email dated 10/21/25. Incident report from Walter Brooks dated 10/20/25. Email from Walter Brooks House Program Director, Parks dated 10/20/25.
Can you just state the exhibit? Sorry, can you just state the letter though? Like the H?
Oh, I'm sorry. Which one was it?
Well, you skipped a few, so let's just start where you were at. So let's go with Exhibit I. It's okay. Exhibit I, residential discipline report.
Okay,
I think
Exhibit
we were
I,
there, right,
residential
Counsel?
discipline reports
Okay.
×5. Exhibit J, voluntary admission of positive drug test result for prohibited substance ×2. Exhibit K, Redwood Toxicology Labs reports ×3. Exhibit L, State of Connecticut PCS offender misconduct reports ×4. Exhibit M, photo of assaulted offender. Exhibit N, signed halfway house agreement. Exhibit O, State of Connecticut BOPP revocation hearing summary dated 1/21/25. Exhibit P, State of Connecticut BOPP preliminary hearing summary dated 1/9/24. Exhibit Q, CT state statute for disorderly conduct. Exhibit R, CT state police report for case number 2500373213. Please note PCS has requested police report but has not yet received it. By the filing of this violation, report will be included as an addendum if needed.
Thank you. So I do want to note a few things on the record. So Exhibit J, I'm going to modify it to state 3 voluntary admissions. I did receive 3 and not 2. As well as Exhibit L, it's going to state 2 misconduct reports. I did not receive, I don't know what that number was, 3, 4. Yeah, I only received 2. As well as I did not receive Exhibit H. And I did not receive Exhibit R, so those 2 documents will not be admitted into evidence for today.
I wanted to clarify, I was going to beat me to it. Exhibit H, which is the video footage from the Walter Brooks.
No,
You don't
I didn't
have that.
receive
Okay,
it.
I don't have that.
Admitting that, and I did not receive R as well, so
Okay.
we will not be
No, I
admitting
wasn't
that
able to
for-
get it in time, so it was.
Yeah, no
kind of a little
problem. So
nutty.
we're just not going to admit them for today's hearing. Council just confirmed you did receive the parole violation.
Yes, I have everything else, but those 2, yes.
Perfect. I did not receive any exhibits from the defense at this time. Oh, wait, I'm sorry. Let's go back. Officer Bennett, you did submit an addendum, correct?
Oh, you know what? I think I read an older list of evidence.
That's okay. We have
I'm
everything
sorry,
that
that's
you
probably why
said.
it's confusing because the police
No.
report was included. Okay, sorry about that.
No, you're okay. We're all on the same page with that, but you did submit an addendum. Do you have that in front of you to read for us to?
I can get it.
Thank you.
Sorry, you want the addendum from the tickets?
Yes, please. Can you please read that for us? Actually, you know what? I'm gonna hold off on that because when did you receive? Was that after the 7 days?
The addendum
Yeah.
or the
Was it
actual
after-
behavior?
Let
The
me,
behavior
let me
was
just
on the day of his
because,
remand.
no, the addendum, if it was submitted after the 7 days, this is a preliminary hearing. It's just, it was pending a while. I just want to see what the date it came in, because if it was after the 7 days, it won't be reviewed at this point.
It was after the 7 days, the addendum. that
It
I
was, all right,
submitted.
so we're gonna actually skip that part. Council understood, exact work sent after the 7 days, so we're not gonna move forward with that information. Is that okay?
Yes, the addendum.
The addendum.
Okay, Mr. Brown, the addendum we spoke about regarding the 2 incidents is after the 7 days. That's not going to be discussed today. Okay, so
Well,
don't,
it's not gonna be the addendum submitted if it's
Correct.
brought up in testimony for
Correct.
today.
I'm not going to comment on that. Thank you.
Thank you. So we're not
Thank
gonna, we're not gonna review that at this point. Now it is, we don't have witnesses at this time. I don't have anything from the defense at this time. Council, do you need any time to submit any?
No, not at this point, not for the preliminary here.
Okay, thank you. So, it is now the state's opportunity to make a short statement, call any witnesses, and testify with respect to probable cause and the severity of the allegations. So, Officer Fennick, would you like to make a statement?
I just wanted to point out, although Mr. Brown wasn't formally charged, that doesn't mean that the behavior didn't occur. And that's all.
I didn't do anything to anybody.
Kenneth,
I know.
it's not your turn right now. Hold on. I just told you we have to do this
Yes, sir.
today.
Pardon me,
All right.
ma'am.
That's all I have.
Thank you. And counsel?
Yes, just briefly, this is only a preliminary hearing, if I may. Theo Bennett, I understand what you're saying under charge number 2, under obedience to the law. The PCS and the board has a different standard in criminal court, obviously. Although it meets the conduct of the disorderly conduct as to what allegedly occurred, and obviously Exhibit H, I don't have the video footage. As far as you know, as of today, December 11th, there has been no formal, because I believe it, one of your documents indicated that you have confirmed that there were warrants coming, correct?
I believed that they were at the time. I have not seen any been signed.
Okay, and as of today, December 11th, you're not aware of any warrants being served on Mr. Brown as of today for the disorderly or for the alleged, there were some photos of some type or a text. Is that correct?
Correct. As of today, no.
All right, all right.
As far as I know.
Correct, and you did speak to my investigator at some point in the month of November, and he inquired regarding any potential warrants, or if you knew of any warrants that were forthcoming, and I believe, I don't want to put words in your mouth, but you did tell him there was nothing at this time, correct?
Correct.
Okay, and I also want to add my investigator also reached out to the state police, and they wouldn't give us any information on warrant situation, but we've tried every avenue to see if there were any forthcoming warrants, with the understanding of how the board and PCS treats in obedience to the law charge. When there is no warrant in hand, we go forward now as we are now on a technical violation, and then if a warrant pops up down the road, it's the same facts, same day, same incident, and there's a criminal charge for that. I just want to make that part of the record. And Mr. Brown, I do not want you to comment. I'm just going to put some statements on the record. On the charge number 2, my client does admit there was a verbal dispute with the other individual. I understand some with the evidence that was presented, but I don't have the video to kind of see exactly what happened. But I did speak to my client, and my client's position is there was a verbal argument. He's not disputing that. And once again, I understand we use a different standard here, especially for a preliminary hearing. Charge 3 under the drugs, my client does admit that. He does have a substance abuse issue. He's not trying to hide that from anyone. Mr. Brown, briefly, regarding charge number 4, the issue with the telephone, your cell phone, and the search, could you let the hearing examiner know if you recall what occurred that day? And we're not talking about the claim you made with the state police. I'm talking about what occurred on October 21st. That's all you can speak about at this hearing, okay? Regarding the search. Go ahead.
On that day, I called Mrs. Bennick. I said, Miss Bennick, listen, I'm having issues down here at this halfway house. I need help. You know, I don't want to get jammed up. I'm not trying to go back to jail. I said, listen, you know, I've been doing treatment. I've been going to the app. I haven't since I've been going to the app, I haven't had any dirty urines or anything. So she told me, she said, all right, Brown, just come on down to my office. We'll talk about it. We'll try to get you into a different place. So this way you won't get jammed up. You won't be in jail. I said, all right, well, that's fine. And the program director, he ended up getting fired for whatever reason. So he brought me down there. I'm thinking, all right, you know, she's gonna help me. This is the main reason why I called and asked for that help from her, so I wouldn't get jammed up. See, they brought me down there to her office. I go to her office. She says to me, "Hi, what's up, Brown? Hey, what's up, my favorite troublemaker?" I'm like, what are you talking about? So they call me in. They call me to the back. Next thing I know, I'm in handcuffs. She put me in cuffs. I said, "Yo, hey, what's going on? What is this?" I called. I asked you for help. If I would have known this, I wouldn't even have called. I wouldn't even have asked for your help. They take my phone. She takes my phone. She says, "Oh, what are you doing with the phone? Blah, 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 blah." I said, "I'm not doing nothing with the phone." She says, "What's the code?" I said, "I can't give you the code. You have to hit with my thumb. There's a thumb code with my fingers." Next thing I know, I'm in jail, miss. And ever since then, I've been in here ever since.
All right, Ken, that's all I need you to say on that. My last question to you is regarding the April 8th incident with the dental appointment. I know it's just a technical and it's relatively minor in my opinion, but it's still one of the bases that you got charged with under halfway house placement. Did you go to a dental appointment on April 8th of 2025?
Yes, I did. And when I went, they told me that they do not accept my insurance. They said that due to the fact that I have Husky D insurance, I cannot and I will not be seen.
Okay, thank you. I don't have any other comments. I said this is a preliminary hearing, so kind of limited to what I can add, but I just wanted to put those things on the record. Thank you.
Officer Bennett, any additional comments?
Yes, I told him to report to the office, which is typically what we want to do if we want to have a remand that is safe for officers and public safety. He did not say he needed the thumbprint for the code. I said, what is your code? Because I'm going to search your phone. And he said, nope. What else? He had positive urine since apt. I don't know where he's coming off. I don't know where that's coming from. And as far as the April 8th, I know you said it's little, but he did not have an appointment. He filled out a pass saying he had an appointment, but he did not have one. So it just shows to what he does, like his intentionally trying to get out into the community without permission and doing things that he's not supposed to be doing.
Janet, don't say anything else, please.
So both sides are
Yes.
no additional comments. So I will just take a moment. You're okay until I announce for me to announce that. Thanks. So I have listened to all the testimony today. I've also reviewed all the evidence, Mr. Brown. I'm going to announce my findings now. So with charge number 1, the condition of program participation, I'm making a no finding of probable cause. Based on the information reviewed, the state failed to submit sufficient evidence in support of that charge and the elements were not met. On charge number 2, the condition of obedience to the law, I am making a finding of probable cause based on the evidence submitted in states exhibits A, D, F, G, and Q. On charge number 3, the condition of drugs, I'm making a finding of probable cause based on the admission in today's hearing, as well as in states exhibits A, D, I, J, and K. On charge number 4, the condition of search, I'm going to make a finding of probable cause based on the testimony presented at today's hearing. Second. On charge number 5, the condition of halfway house placement, I am going to make a finding of probable cause based on the evidence presented in states exhibits A, D, F, G, I, L, and N. With that, Mr. Brown, I'm also finding that the acts are serious enough to warrant revocation, and I've also determined that you should be detained while you await that revocation hearing. So the facility records office will be notified of that. Officer Bennett is now aware of it. So what happens next, Mr. Brown, is that your revocation hearing will be scheduled within 60 business days of your remand to custody. At that hearing, myself or another hearing examiner will determine if you violated the conditions of your parole. And if so, they will make a recommendation regarding whether your parole should be revoked and what, if any, sanctions should be imposed. So that does conclude today's hearing. Any questions?
No. Okay, once I get the date, I'll set up another call with you and go over what step 2 looks like, okay?
I have a question, man. I want to say this. I was working and I had a job. Then I worked at LAZ last and I worked at Cube Group. And then they're saying, they don't even have a warrant for this so-called assault. Why am I in jail? I don't even.
Kenneth, hold on. The background information, as I explained to you, that comes in if there's going to be a second hearing, which there is. That comes in at that part. It's not for today, and I told you that a couple of times. And regarding that warrant, I put some things on the record, and once we get to the revocation on these charges, we'll see what comes of that, if anything, and I'll make those same arguments again, okay? Just got to wait for that date, and as of right now, on this violation, your hearing is going to be scheduled within 60 business days as of right now, because there are no cases pending in any court in Connecticut. Okay, I'll set up another call with you as soon as I get the date.
Theo
So if there's
Trusello, can I
no
ask a
cases-
question?
If there's no cases pending,
Because as I put on the record, it's a different standard at a preliminary hearing with the Board of Pardons and Parole than it is in court. This is an administrative hearing. It's not a criminal proceeding. I explained that to you.
Thank you, Mr. Brown.
Just hang tight.
Yeah.
Can I ask a question as far as the no finding on the program participation?
No, we
The-
cannot go through that now. Sorry, Officer Bennett.
I'll do that
I
at the
can't-
revocation hearing.
Well, I have a lot more hearings to get to, but my decisions are final with that. Yeah, it'll
Okay.
be up in the summary. If you have
Okay.
any additional questions, you can call my supervisor for that stuff, okay?
Okay, thank you.
All right, thank you.
Bye,
Thank you.
Kenneth. I'll talk to you
We'll see you
soon.
soon, Mr. Brown. This concludes
All
the
right.
preliminary hearing for Kenneth Brown, inmate number 32600.
Thank you, Gil Bennett.
Thank you, Council NPO Bennett.
Thank you.
See you soon, Mr. Brown.
all right. Take care.
Alan, I just want to go.
Hi,
Hi, Officer Barris. We're gonna try.
hi,
to
it's
connect-
Maribel.
Hi,
It's
we're gonna,
Maribel's.
yeah, we're trying to connect to Hartford now. We'll get them going soon, hopefully. Alan, I just tried to contact Hartford and it says that they're offline. Do you see that as well?
Mhm. So we don't know if we're gonna see the hearing?
We don't know what's gonna happen. Just hang tight with us, Marius. We'll hopefully figure it out sooner than later.
Okay, perfect, thank you.
Do you see that it's offline? Okay, Officer Barry, so we just contacted Hartford and they said that because it's 12 o'clock, they will not have it down for us because it count time. They asked us to do it at 1, so we're gonna try to hear him at 1 o'clock. I'm running still behind though, but we're gonna attempt to get to Hartford at 1. If you can still.
Okay, I'll try to be available, okay? Because I had some other stuff scheduled for that time. So
Okay.
I'll try to see if I can rearrange my schedule, okay, and be online for 1.
Okay, sounds good. I mean, if you do want to be present, we can see what happens around that time. If you're not able to make it, we'll see if we can try to work something else out. Let me know, okay?
Yeah, absolutely. If I'm on, I'm gonna be, I'll switch into the to the hearing. Can I disconnect now and come back in at 1?
You can, whatever works best for you. If you wanted to just turn your camera off and mute it,
Yeah.
whatever works best for you.
Okay, thank you.
Thank you. I appreciate it.
Yeah, bye-bye.
I'm on the phone with Corrigan right now, with a captain. And we're trying to get Corrigan connected.
Perfect. Thank you. Alan was just over there trying to call as well. But I guess just keep us posted.
Yes, I'm on the phone with Captain Ashkinson.
But
I can't tell, are we trying to dial into them in here in Teams or not yet?
I've tried about 3 times.
I could do it on my end, I just don't want to do it if you're doing it.
No, well, you can do it at the same time, Kristen says, but yeah, I'll try one.
Yes.
They're on it right now, they're working on it.
Okay, so we're calling in and they,
Yeah, call in.
and they'll just answer. Okay, thank you.
Yep, bye.
Thank you. Good afternoon. Good afternoon.
Hey, we made it. Who you want first?
Mr. Contois? Did I say
Contois.
Contois? Yeah, thank you.
Councilors, you can come in, brother.
Officer DeBather, I do see that you logged in with us. I just want to let you know we're running very behind at this point. We're only in Corrigan. So just.
Okay.
Yes, all right, thank you.
Any estimated time or?
I have nothing for you. I'm sorry.
Okay, no worries.
Yeah.
I'll talk to you later.
All right, thanks. Good afternoon, Mr. Contois. We're gonna get started, okay?
Yes, ma'am.
So good afternoon, I'm Parole Officer Trusello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Robert Contois, inmate number 235386. Today is Thursday, December 11, 2025, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office in Corrigan Correctional Center. Can you please state your full name and DOC inmate number for the record?
Robert J. Contois III, 122673, and inmate numbers 235386.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is this afternoon is your attorney. Can you please identify yourself for the record?
Good morning, Peter Matthews with the Public Defender's Office, Mr. Contois.
Thank you. So this is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oaths. Mr. Contois, can you please raise your right hand? You solemnly swear, solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, to help you God upon penalty of perjury.
I do.
Thank you. So we're going to go over the procedure for today. So first, I'm going to read your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits filed for the record. The state will then, the state's not present. Sorry. Let's start again. The state is not present at today's proceedings. However, you will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I'll inform you my findings, which will be based upon the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
So you have important rights, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
I believe so.
Yes. It would have been on November 25th you signed for it, it looks like. Does that sound about right?
Yeah.
Okay. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
All right, we're going to review the charges the charge that the state, your parole officer, is bringing against you, and the information underlying that charge. So on charge number 1, the condition of obedience to the law, the charging officer reported that on 11/22/25 at approximately 17:31 hours, Troop D responded to a domestic disturbance in Brooklyn, Connecticut. Troopers conducted an investigation and determined that you were the primary aggressor in a disturbance and pushed the victim. Based on your actions, you were arrested by Troop D and charged with Connecticut General Statute 53A-182, disorderly conduct. This is evidenced by Exhibit B. The state has filed the following exhibits that have been marked for identification purposes as Exhibit A, the signed conditions of release, Exhibit B, the remand into custody, Exhibit C, the parole violation report, Exhibit D, the notice of parole violation / parolee rights, and Exhibit E, the state of Connecticut criminal information summary. Counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes, we did.
Thank you. I did not receive any exhibits from the defense at this time. Do you need any time to submit anything, counsel?
I do not, no.
We do not have any witnesses, so now it is the defense's opportunity to respond, make a short statement, call any witnesses, and testify with respect to probable cause and the severity of the allegations. So, counsel?
Thank you. So the sole basis for the violation is that disorderly conduct arrest on November 22nd. I did take a look at the evidence, and I don't think the very brief statement provided in Exhibit plea that Mr. Contoy had pushed someone is sufficient to establish probable cause. There's no statements, there's no details about what happened. The police report is insufficient to establish even the most basic details about this incident. I will also note he received a non-surety bond. So I don't know for sure whether it can be established that there was a probable cause finding in court. If there's no bond, it's not necessary for a court to make a probable cause finding. And I have no evidence either way as to whether one was made here or not. So I don't think there's any evidence here that can be presented to show that there was a probable cause finding by a judicial body that they can rely upon when making a probable cause finding here. If there is a finding made with regard to this charge, I would say that the incident is not serious enough to warrant revocation. He's been on parole since 2022. There's no noted prior misconducts. This appears to have been a very minor incident where he was released on a non-surety bond. He is certainly willing to continue working with parole going forward, and I would ask for him to have the opportunity to do that. Thank you.
Thank you. And announce my finding. So on the charge of obedience to the law, Mr. Contoy, I am making a finding of probable cause based on the evidence presented in states exhibits A, C, and D. With that, I'm also finding that the act is serious enough to warrant revocation, and I've also determined that you should be detained while you await your revocation hearing. So the records office at the facility is going to be made aware of that, as well as your parole officer. So what happens next is that once that case is disposed of in court, we'll be notified of that and bring you back in for a revocation hearing. And at that revocation hearing, myself or another hearing examiner will determine if you did violate the condition of your parole. If so, that hearing examiner will make a recommendation regarding whether your parole should be revoked and what, if any, sanctions should be imposed. So it does conclude today's hearing. Any questions, counsel?
So, Mr. Contoy, once you resolve that case, then we'll get the hearing scheduled, okay?
Okay, my thing is that I have a witness who is there. The only thing is.
Don't put it on the record now about what happened, okay? You gotta deal with that in court, okay?
Oh, okay.
All right. Thank
So
you.
once that's concluded, we'll bring you back in for the revocation process, okay? For a hearing, okay? Thank you,
All
Mr. Contoy. So this concludes the preliminary hearing for Robert Contoy, inmate number 235386. All right, hopefully we'll see you soon, okay?
Yes.
Great. Thank you, counsel. Attorney Dean, I'm just checking that you're with us. Hi.
Yes, good morning, or sorry, good afternoon, I should say.
It's afternoon. Hi, are you Mr. Maniz?
Yeah, sorry my appearance. They just ain't gave me no razors in here. They're just short-handed on razors, so I'm sorry.
Oh, no worries. No need to apologize, okay? We're gonna get started though, if that's okay.
Yes.
All right. So, good afternoon. My name is Parole Officer. I'm just making sure no one should be here. Yeah. My name is Parole Officer Trisella, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning John Maniz, inmate number 189917. Today is Thursday, December 11th.
It's 189919.
That's what I have written, and I didn't say that at all. I said 7, right? I said 7 like 3 times. All right, I'm gonna try again. Okay, so this is a preliminary hearing concerning John. I'm sorry, also. This is a preliminary hearing concerning John Maniz, inmate number 189919.
Correct.
Yeah, that's what's in front of me too. That's scary. Okay, so today is Thursday, December 11th, 2025. And this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Corrigan Correctional Center. Can you please state your full name and DOC inmate number for the record?
John Michael Moniz. My inmate number is 189919. My birthday's 2/4/1964.
No birthdays, but thank you. I appreciate that.
All right.
So this is a public hearing, and public access to this hearing is available via video live stream. Present this afternoon is your attorney. Can you please identify yourself for the record?
Yes, Hannah Dean on behalf of Mr. Moniz. Good morning, or sorry, good afternoon, everyone, I should say, sorry.
Thank you. No, that's okay. So this is a preliminary hearing, which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Moniz, can you please raise your right hand? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. So we're going to go over the procedure for today. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my finding, which will be based upon the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
So do you have important rights, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
So we're now going to review the charges that the state your parole officer is bringing against you and the information underlying each charge. So on charge number one, the condition of obedience to the law, the charging officer reported that on November 22nd, 2025, you, Mr. Moniz, were arrested by the New London Police Department and subsequently charged under Connecticut General Statute 14-227A, operating a motor vehicle under the influence of drugs and or alcohol. You were taken into custody, and while at London Police Department, you submitted a breathalyzer at 2 different times to officers at the 0229 hours. Your first breath sample was 0.0693, and at 0249 hours, your second breath sample was 0.0621. On charge number two, the condition of no consumption of alcoholic beverages, the charging officer reported that on November 22nd, 2025, you, Mr. Moniz, were arrested and charged by the New London Police Department under Connecticut General Statute 14-227A, driving under the influence. On May 23rd, 2019, you reviewed, initialed, and signed your statement of understanding and agreement conditions of parole with your supervising parole officer. Under the section listed of additional conditions set at hearing, alcohol beverage consumption was reviewed. This condition specifically states throughout your period of parole, you're prohibited from the consumption of alcoholic beverages. You are required to submit random toxicology screens to monitor compliance. The state has filed the following exhibits that have been identified for today's purposes as Exhibit A, the remand to custody order, Exhibit B, the parole conditions, Exhibit C, the notice of parole violation, Exhibit D, the parole violation report, and Exhibit E, the New London Police Report 2500029722. Counsel, did you and your client receive a notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes, we have.
Thank you. I did not receive any exhibits from the defense at this time. Do you need time to submit any documents?
Not at this point. Thank you very much.
So we do not have any witnesses, so it is now the defense's opportunity to respond, make a short statement, call any witnesses, and testify with respect to probable cause and the severity of the allegations. So counsel?
Yes, thank you very much. Nothing as to the charges themselves, but I did just want to put a few things on the record concerning the seriousness. My client has been on supervision since 2019 without issue. He had been doing very well in the community, so well that he had dropped down to annual reporting. My understanding is that he had no misconducts or sanctions while in the community, and he was doing a number of positive things. He reports that he'd been working full-time at CWPM in New London since he was released in October of 2019. He worked there as an operator and loader, where I believe he works with heavy machinery. At that job, he found a very positive community in his supervisor, who has been a very positive support in his life. The two of them have attended 12-step meetings in the community. My client also reports attending Yale Health in New London for individual therapy. Since his remand, my client's been doing religious services, which he finds to be helpful, and he has not gotten any sort of tickets since that remand. While in the community, my client had self-sponsored his own private apartment, and right now, his biggest concern is losing his housing. If he is not able to get back into the community within the next couple of months, he will, unfortunately lose his housing. He doesn't have, the savings to sustain the apartment for that long, but I know it was quite, a process getting that housing. So that, I believe, is, a very big worry for him. However, he is someone who I think has shown that he is very amenable to parole supervision and does well on that type of supervision. Mr. Moniz, is there anything I left out about, your background and then the seriousness that you wish to say? I would just ask that you don't say anything about the pending case in court right now.
No, I do a lot of positive things for my mom and my sister. I get the medication for my mom. I do everything I can for family, friends. And at work, I'm a chief. I'm the floor manager. I treat everybody equalized. Even I don't know. I've been doing good. My boss right now went through lung surgery right now, and he's in a coma right now. Otherwise, he probably would have came and spoke.
Thank you very much.
Yeah.
No,
I appreciate your statement, Mr. Moniz. I'm just gonna take a quick second, then I will announce my findings. So on the charge number 1, the condition of obedience to the law, Mr. Moniz, I am making a finding of probable cause based on the evidence presented in States Exhibits B, D, and E. And on charge number 2, the condition of no consumption of alcoholic beverages, I'm also making a finding of probable cause based on States Exhibits B, D, and E. I'm also finding that the acts are serious enough to warrant a revocation, and I've determined you should be detained while you await that revocation hearing. So we'll notify the records office at the facility as well as your parole officer. So what happens next, Mr. Moniz, is that once that case is concluded in court, we'll be bringing you back for another hearing, a revocation hearing, to determine whether or not you have violated the conditions of your parole. At that hearing, myself or another hearing examiner will make a recommendation regarding whether your parole should be revoked and if any sanctions should be imposed. So at this time, that does conclude the preliminary hearing. Do you have any questions?
Mr. Moniz, I would just say that I will be getting in touch with you and your attorney for the criminal case. And as soon as that resolves, I will let parole know so that we can try and get in for that revocation hearing. I can set up a call with you so that we can kind of debrief everything that happened today. And that way I can answer any questions you might have about the process. Okay?
yes, thank you.
All right. Thank you.
both.
I'll email your counselor to set something up. Thank you.
Thank you.
Thank you. Thank you both. So this does conclude the preliminary hearing for John Moniz, inmate number 189919. All right, hopefully we'll see you soon, okay, Mr. Moniz?
Yeah, thank you.
Thank you. Thank you, Attorney Dean.
Thank you.
Alan, so Osborne's not showing that it's offline, but when I hit to call it, it just disconnects. What am I missing? Supervisor, can you try calling Osborne on your end? Because it's not working in the room. Alan's about to go try on his end.
Yes, I could call. Do you want to try McDougal, see if they're waiting for you and go with them?
Yeah.
It's up to you.
Yeah, I will try to go now. Oh, here's an answer. Hi, good afternoon.
Good afternoon.
All right, I just need to confirm that I have everybody here with us. No, where did she go? Okay, I'm going to, because I don't see Officer Diviler with us. Let me try to call. Oh, her screen froze. Hold on. Not her screen. I really don't see her.
Hello? Hello?
Can you hear me?
Yes.
Perfect. All right, we're gonna get started. As long as you're available. No, you're good? Everyone's still here?
I'm just gonna need a minute, okay?
Yeah, absolutely. Okay, so since we're just waiting for a moment for Officer Divider, I do want to put on the record that the hearing today scheduled at 12:15 for George Figueroa, inmate number 192694, will not be moving forward as his attorney has waived today's proceedings. Thank you. Thank you. We're going to get started. So good afternoon. I am Parole Officer Chisello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Luis Iazari, inmate number 297854. Today is Thursday, December 11th, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Osborne Correctional, no, we're not at Osborne, we're at McDougall, sorry, McDougall Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Alex Rangel Vasquez, formerly known as Luis Irizarry, inmate number 297854.
Okay, Mr. Vasquez, would you rather be addressed by Mr. Vasquez?
Please.
Okay, sorry about that. Thank you for clarifying it.
Thank you.
So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. This afternoon is your attorney. Can you please identify yourself for the record?
Yes, Hannah Deed on behalf of Mr. Vasquez.
Thank you. And also is your charging officer. Can you please identify yourself for the record? You look frozen to me. She look frozen to anyone else?
Yes.
Darn. Let's give it a second, because Osborne just emailed that they were frozen. We were frozen.
That's unfortunate.
It's been a day, yeah.
Really.
See, I'm gonna send her a quick email and see if we can get her back in. Kicked her out and she can't get in. All right, I feel like we could probably hear you. Okay,
There we go.
perfect. All right, we're gonna get through this. I'm giving myself the encouragement. Glad you guys are here for it. All right. So we were at where you were gonna identify yourself, Officer Diviler.
Officer DeVilder, Hartford Special Management Unit.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I'll review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that it is a better or weightier evidence must establish that, more probably than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to an appropriate sanction. A recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. Mr. Vasquez and Officer DeViler, can you both please raise your right hand? Thank you. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I do.
Officer DeViler, you were muted. Yeah.
I do.
Thank you. So we're going to go over the procedure for today. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state your parole officer is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will then have an opportunity to present all relevant testimony, subject to cross-examination and any relevant documents. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings. And if I find you have violated one or more of the conditions of your parole, the state will have an opportunity to speak towards your background and history. And after the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin? Mr. Vasquez?
Oh,
No?
no, sorry.
That's okay. So we're going to go over your rights for today. So you do have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive written notice of charges of violation. Did you receive that written notice?
Yes.
Do you also have the right to review the evidence against you before this hearing? You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
Perfect. So we are now going to review the charges that the state your parole officer is bringing against you, any information underlying the charge. So Officer DeViler, can you please review the charge for us? Oh, you're muted again.
I'm sorry about that.
That's okay. Thanks.
So under Obey All Laws, charge number 1, obedience to the law. On 11/25/2024, you sent an email to your parole officer stating, I, Alex Vasquez, formerly known as Louis Irizarry, inmate number 297854, do hereby humbly request today on November 24th, 2024, for an appeal form for my court-ordered parole stipulations. Thank you and have a wonderful day in Southington. Your statement provided reasonable suspicion that you are aware of where your supervising officer lives. On 11/27/2024, your cell phone and electronics were seized for further analysis. You conducted a search and paid for a background check on your officer on the website www.golookup.com. On 1/24/2025, you were remanded to custody for a separate issue and were found to be in possession of an unauthorized tablet. A search conducted of this tablet showed that you were in possession of photos of the parole officer's residence. You also had notes on your supervising officer's personal information to include her maiden name, family members, and their addresses as well. Due to the aforementioned, you were arrested and charged with disorderly conduct, 53A-182, threatening second, violence to terrorize, 53A-62A-2A, and harassment second, 53A-183, under that docket number. Your next court date is 9/16/2025.
Thank you. You've also submitted evidence in support of the case. Can you please identify the exhibits for us?
Yes, so the evidence submitted was A, PCS conditions, B, remand to actual custody order, C, parole violation notice, D, parole violation report, E, CSP Troop H, case number 25000352238. And then we also additionally submitted F, which was Parole Supervisor Wilkie's letter, G, which was Parole Supervisor Plord's letter, and then H, which was the news article regarding the case.
Thank you. You also did submit addendums to the case as well. So can you please review both of them? The first one was submitted on November 24th, and then the second one on December 9th. So can you please start with the one in November?
I do not have that directly in front of me.
Okay, I have them, so I will say it.
Thank you.
No problem. So the first one was submitted on November 24th of 2025, and it states, Irizarry was sentenced under docket ending 799S on 11/12/2025. He was found guilty of threatening second, violence to terrorize, and sentenced to 9 months jail. The charges of harassment second and disorderly conduct were thrown out. The second one that I stated was submitted on 12/9/2025 does state the additional evidence submitted as identified by Officer Divider, which is exhibits F through H, as well as states that in addition, P.O. Brayfield will be called as a witness at the revocation hearing. Counsel, to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
We have, yes.
Thank you. So I did receive an exhibit from the defense. I have exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Counsel, do you need time to submit any other documents?
Not at this time. Thank you.
Perfect. So at this time, it is the state's opportunity to call any witnesses, present evidence, and speak to any of the evidence submitted. So Officer Diviler, do you wish to call the witness today?
Yes, I would like to call the witness to speak more on the history, background, and recommendation, not the fact-finding portion.
Okay, so then we'll hold off for now. We'll revisit it if it moves on to that portion of the hearing. Makes sense? Good? Okay. Great. And then counsel, so it is also your opportunity, Officer Diviler. Do you have any statements towards the charge?
Yeah, I would just like to mention on September 11th, defense counsel did concede that probable cause existed in the preliminary hearing.
Counsel, it is now your opportunity.
Yes, thank you very much. I would note defense counsel conceded that there was probable cause. Defense counsel didn't concede that there was preponderance of the evidence for the charges, which is the standard at the current hearing. However, I don't have any comments or argument as to the actual charges themselves. I just want to note very briefly that the only conviction that was that one misdemeanor charge noted in the addendum 1 that was read. Thank you.
Thank you. Just gonna take a moment. I'll announce my finding. So on charge number 1, Mr. Irizarry, I am finding that he violated the condition of obedience to the law based on that conviction of threatening second on November 12th, 2025, and he received a 9-month jail sentence. In addition, the evidence in support of the charge states exhibits A, D, and E. So that does conclude the fact-finding portion of today's hearing. Before I make my recommendation, the state will have an opportunity to speak to your background and history, and after the state is finished, you will have the same opportunity. The purpose of this part of the revocation hearing is to help determine what outcome I would recommend. So, Officer Diviler, it is now your opportunity to speak. You would like me to swear the witness in at this time?
Yes, may you please?
So, Brayfield, you need to please raise your right hand. You solemnly swear, solemnly affirm as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, and shall be brought upon penalty of perjury.
I do.
Thank you. Go ahead, Officer Diviler.
So I'm gonna just ask that Officer Brayfield make a statement in regard to this case.
I started supervising Luis Irizarry, aka Alex Vasquez, on 2/15/22. He is on special parole for a sex assault against a minor in which he sexually assaulted a prepubescent male that was related to him. The victim reported that he was forced by the offender to engage in penile and oral contact. The victim reported the offender also made him touch his penis with his hand. The victim reported the offender attempted penile, anal, and penetration on the victim, and that the offensive behaviors occurred on more than one occasion. He is a registered sex offender. He is not permitted to have contact with any minors, including his minor son. He disclosed during the full sexual history polygraph that he had multiple minor victims. This means, in addition to the incident offense, he has a pattern of sexually assaultive, deviant behaviors against minor victims. He has a history of repeated victimization of minor males and females related and unrelated to him, further increasing his risk to sexually reoffend. The offender's threatening and harassing behavior has increased over time. I attempted to intervene and modify his actions to get him in compliance with his parole conditions with no success. Given the offender's status as a sex offender and his documented history of violence, and considering the targeted and escalating pattern of behavior, I believe there is significant and growing risk of violence. The transition from passive searching and emailing me to active collecting personal images of my residence and researching my family and threatening to burn down my house signals a deepening obsession and disregard for legal and professional boundaries. He has proven that he has a difficulty controlling his emotions and reacts in ways that create a risk to public safety and to my personal safety, as well as my family's safety. The offender has a history and behavior and pattern of blaming those in authority for his inappropriate actions. The offender's threats and harassment have completely disrupted my life. I've had to live in constant fear, always looking over my shoulder, worried not only for my safety, but for my family's. His actions didn't just affect me, they affected the people I'm closest to. What disturbed me even more was his behavior in the courtroom. While I was testifying, he mouthed the words, "I hate you," at me twice in front of the judge. That moment showed a complete disrespect for the court and authority and made it clear that his intimidation and threat to me is ongoing. I am requesting a full revocation hearing. I do not want to be in fear, or I don't want my family to be in fear for the next 4 years. Thank you.
Thank you. Anything additional from the state?
Yeah, so I'd just like to talk a little bit about his disciplinary report. I don't believe that he's taking this period of incarceration seriously, as evidenced by the recent disciplinary reports he's received. On 10/28/2025 and 11/26/2025, he received tickets for refusing housing, and on 10/23/2025 for interfering with safety and security. These DRs illustrate someone who is continuing to defy authority, not someone who wants to be compliant in the community. And I also just want to go a little bit further on and just make a statement in regard to our recommendation and why. The offender should not be given an opportunity to be released on supervision. He should be fully revoked. Irizarry has demonstrated an extremely assaultive history in many forms, such as assault 1 convictions that include multiple stabbings, sexual assault convictions, and threatening serious bodily harm to authority. Not only does he have a history of assaulting DOC personnel, but now he is threatening even worse to his previous parole officer. He has demonstrated a lifelong history of his inability to control himself either sexually or behaviorally. Even as recently as January of 2025, he pepper sprayed his roommate, who he claimed woke up his minor son that he was not even supposed to be with. This is a spiraling and dangerous pattern of behavior and evidence of escalating threats. I'd like to mention that this is Irizarry's 3rd violation of parole and 2nd criminal violation. He was given 2.5 months sanction for failure to register and 7 months following a technical violation when he had contact with his son. He is not someone amenable to supervision, as he just continues to do what he wants to do despite his conditions. The recent DRs also illustrate his chronic pattern of refusing to comply with rules. Despite parole's attempts to modify Irizarry's non-compliant and violent behavior, he continues to engage in the same. He clearly has a negative attitude towards supervision. Even in a court of law, while he's on trial for threatening parole officer Brayfield, he continued to harass her while she is on the stand. But this isn't just about P.O. Brayfield, this is about anyone in authority. He is violent, unpredictable, and this places anyone in authority in jeopardy. We need to set a precedent here and prevent any parolee from thinking that this is acceptable behavior. Again, this is not someone that should be released. Irizarry's pattern of assault, sexual assault, and threatening conduct is not compatible with the welfare of society. Thank you.
Thank you. And counsel?
Yes, thank you very much. I would like to start by addressing the testimony put on the record by P.O. Brayfield. First, everyone in this room knows what my client is on parole for. That's not a mystery. We have his information. He wouldn't be in front of us if he wasn't on parole for something that carried a significant penalty. So I just want to put that on the record. Secondly, the polygraph results mentioned, I would ask that not be considered. That nothing of that sort is in evidence here today. We don't have any reports from the CTPSB that allegedly conducted these results. So I do think that that's relevant to bring up. Third, I want to make it clear, my client has not at any point been arrested for a new sexual offense. My client's prior criminal remand had to do with a failure to register, but he has not been arrested since being on supervision for any new alleged sexual conduct. So I did just want to note that. Additionally, I wanted to note concerning the information put on the record by P.O. DeValter. I did just want to note that, first of all, the pepper spray allegations were encompassed in my client's prior parole violation, which he already was sanctioned for, and that sanction has expired. So I do just want to note that he already was sanctioned for that. We, have already dealt with that. That's not currently part of the present charges that he's here for. Secondly, I want to note concerning the comments about the DRs. This is unfortunate. However, the sad reality is that individuals who are incarcerated for sex charges are oftentimes victimized by other individuals in the facility due to the nature and, kind of consensus and, public view on those specific charges. So I do just want to know, as stated, there haven't been any sort of DRs for violence. Like, I just want to note on the record, it was said that they were for refusing housing and I think the other one was tampering with safety and security. So I just wanted to make it clear concerning that. Now, as far as the conviction, I did just want to put a few more things on the record. What we're speaking about here is an A misdemeanor. The Connecticut General Assembly has made clear that the maximum appropriate penalty possible for misdemeanors is 364 days incarceration, under a year. The specific statute for that offense had to undergo the scrutiny of the legislative process, and that was codified as an A misdemeanor. If the legislature thought that it was appropriate to sentence an individual to more than a year of incarceration for that type of conduct, we would see that reflected in the statute. We don't see that. Additionally, I want to argue that the court in Hartford, after hearing the and reviewing the evidence for this case, found it appropriate to sanction my client to 9 months to serve, not even the maximum allowable under the statute. I would argue that since this was a bench trial, the court had far more information available to it about this incident than anyone in this room does. And after reviewing all of that, the court still found that 9 months was appropriate for Mr. Vasquez. For these reasons, I would argue that the state's argument that Mr. Vasquez should serve a sanction in excess of 4 years runs contrary to what the legislature clearly intended for crimes of this nature, and also runs contrary to what the court in its discretion found appropriate to impose as a sentence. As to the allegations in the submitted statements and from the two POs present today that my client mouthed threats or obscenities to the complainant during trial, I would just note that I was able to get a copy of the transcript from that proceeding. And the only person in that transcript that I reviewed that alleged my client was mouthing anything was Ms. Brayfield. There was nothing on the transcript indicating that that was picked up by the court reporting monitor. There was also nothing on the transcript indicating that any of the various other court personnel that were present observed that occur. I would further argue that the statement that my client had plans to greatly harm his parole officer from P.O. Ploward in the letter is, I would say, a mischaracterization of the charges and the evidence in this case. Concerning my client's background and history, he successfully completed the January Center in 2020 and successfully completed the Connecticut PSB program in 2022. At the time of my client's remand, he was actually doing the program for a second time and was in phase 2. While in the community, he was working full-time at a catering company, and upon reinstatement of his special parole, he's open to being sponsored potentially by his wife or to utilize the Chrysalis Center's scattered site housing program. As an alternative, he's also open to a halfway house in the Hartford jurisdiction. Ideally, parole should help someone re-entering society, and for quite some time, my client experienced that. Prior to 2024, my client had been on supervision for several years without issue. He dropped down to, I want to say, a couple times yearly, or maybe it was just yearly reporting. And so he certainly is able to cooperate with supervision. Unfortunately, he reports sort of this period of experiencing a tumultuous situation with his assigned parole officer, and often felt that despite his best efforts, he was not being heard and not being given opportunities to see his son with parole's permission. Despite undergoing extensive treatment and having, an appropriate individual designated to be his supervisor with his son, he felt that parole was not, allowing him that opportunity, or at least even working with him to let him know what he needed to do in order to be in good standing. Today, we're asking that you consider re-paroling my client in January of 2026. That will be exactly 1 year since he entered incarceration. It is unfortunate the way that this violation was entered, especially since the warrant in the criminal case was served on my client in March of 2025. And this information was clearly known to Parole and Community Services at that time. However, the parole violation for that conduct wasn't served on my client until he timed out on his prior parole remand sanction in August of this year, which I do think deserves some consideration. Additionally, going forward, my client is asking that he be permitted to potentially have parole consider having his wife as an approved supervisor in the visits with his son, so that he can go through the right channels to reunite with his family, which he is more than willing to do. The truth of the matter is, at some point, my client won't be supervised in the community and he will be off of parole. And so he's trying to make the steps now in order to reunite his family so that, he's able to build that relationship with his son. But he wants to do that the appropriate way. And obviously he knows the appropriate way to do that is with parole officer's permission and with an approved supervisor. Thank you very much.
Thank you. Any additional comments?
Yes, I would like to remark on just a couple of things. So I just want to point out that the testimony by Parole Officer Brayfield regarding the TPSB polygraph, it was actually not the polygraph results that she's talking about. They're disclosures that Mr. Irizarry made during that polygraph examination. So he admitted to those behaviors. You mentioned the pepper spray should not be considered, but I believe that it is extremely relevant to speak on that in regard to his history and background. It just shows the type of behavior that is just escalating and escalating. Parole Officer Brayfield would like to speak on one part as well, if I may call her to testify again.
Yeah. Go ahead, Officer Brayfield.
Okay, I just wanted to touch quickly on the approved supervisor process for Mr. Irizarry. It was made very clear to him, the process, in order to get that started. And he needed to be in compliance with all of his conditions. He was not in compliance with his conditions, and we were working with CTPSB treatment in order to attempt to start the approved supervisor process. We couldn't even start it because Mr. Irizarry was non-compliant. One of the non-compliance issues we had was he went to his wife's house without permission. He was told he can't go there because his son is there, and he decided to go there anyway. In addition, I explained to him that just because he wants his wife to be an approved supervisor doesn't mean that we have the meeting, she's approved, and he can have contact with his son. It may be that he is not allowed to have contact with his son throughout the time that he's on parole, depending on the collaborative model that we have. It's not just we do this meeting and then he can have contact. So, it was made very clear to him what he needed to do in order to even start the process. He decided to not do what was told of him. That's all I have.
Thank you. Counsel?
Yes, I just wanted to say something.
All right, go ahead.
One more thing.
Yeah, go ahead.
Sorry. So I just want to state that Attorney Dean was talking about, you know, the legislative factor of this and sentencing guidelines around it, but this is parole hearing, and I really don't appreciate the victim blaming in this case. We need to take this more seriously in this venue because of the role the victim played in an authority position. Thank you.
Counsel?
Yes, thank you very much. First of all, for the record, I would argue I need to be able to defend my client. And my client has maintained from the very beginning that this was a wrongful arrest. And so I am, you know, just advocating my client's wishes. In no way am I victim blaming, I am advocating. So I just want to make that very clear for the record. Secondly, I want to note, you know, the previously, it was put on the record concerning my client having violent history. I do just want to note, I do have his criminal history printout right in front of me. And prior to that failure to register, which was back in 2024, prior to that, my client's last conviction was in, the incident date was in 2014. So 10 years prior, I think that's relevant to note here. There's no violent history within the last 10 years on his criminal history. I think that's appropriate. I understand there's the most recent conviction. We're not, you know, going against that. But I will just note prior to that, you know, it had been 10 years since he had had a case. In addition, I did just want to note, again, my understanding from my client, and please, Mr. Vasquez, correct me if I'm wrong, but my understanding from him is I believe he had gone through the process with his CTPSB treatment and gotten the paperwork and letters from them on, I think, a couple of different occasions that he had turned into parole. Yes. So I do think that he was, you know, trying to take it upon himself to do the right thing, get those recommendations from his treatment provider before he, you know, came to parole. He understood that this was a process and that it wasn't just a one day, you know, quick check-in, we're finished. But I think that he, you know, took upon himself and did his due diligence to, you know, get that paperwork done and did it, you know, a number of different times. That's, I believe he stated on the record 4 times. And then lastly, you know, I did just additionally want to note that I understand that this is a parole hearing and ultimately parole can do what they want. They don't necessarily have to listen to what happened in court. We're not contesting that. I'm just stating that this conduct was considered by the legislature in crafting these statutes, and this is what they thought the appropriate penalty would be. Certainly, if they thought this was more appropriate of longer incarceration, we would see this as a felony charge or something of that nature. But that's not the case we have here. This is a misdemeanor charge. Thank you very much.
Thank you. Any additional comments?
Just briefly, I would like to talk about the approved supervisor packets. So he can submit the approved supervisor packets, but that doesn't mean the process starts. So he was in CTPSB sex offender treatment. However, his therapist in treatment said that he needs to be in compliance with certain other aspects of his treatment in order to even start the process. So again, I explained to him he needs to be abiding by all of his parole conditions before we can get started. So it wasn't just me, it was sex offender treatment saying we're not even going to proceed forward with even having a meeting, doing a screening call, anything like that for the approved supervisor process because Lewis was not in compliance with certain conditions. He also, I know, I just want to touch on the last conviction you mentioned was 2014. He has been incarcerated for, or I guess the last serious assaultive conviction you said was 2014. He has been incarcerated for a long period of time. Before that, he does have a very assaultive history in which he has assault first convictions. And when he was incarcerated, he continued being assaultive with getting DRs for assault on DOC. Thank you.
Yeah. Any further comments?
Just very briefly from the defense, I don't want to go back and forth.
I was going to just say, we're not going to touch upon that sex offender thing anymore. I think it's exhausted at this point. We've heard
correct.
what's needed and what's not needed.
Correct. I don't want to go back and forth. I just wanted to note for the record that, my client, this isn't the first time he's been on parole. He was on parole beginning in 2020 and was on parole from 2020 to 2024 without issue. So it's not, I think it's being characterized that he can't comply with parole supervision when I believe that he certainly can. And I think that he's proved that for those 4 years where there weren't issues. Thank you very much.
You.
May I speak?
Yes, Mr. Vasquez, I would just ask that you not speak concerning the actual charges and just speak concerning your background and history. The hearing examiner said that we had enough information. We've gone back and forth a couple times concerning the approved supervisor, but if there's something in addition that you want to put on the record, you certainly can at this point.
Right, because I see what's going on here, and I feel like I'm being attacked personally, because of my history, and they're not seeing the person that I am. What is being seen is things of my past, things that are, let's say, opinions and not facts. Now, I'm a family man. I've changed my life around. Like Hannah said, I haven't assaulted anybody in 10 years. I haven't caused anybody any physical harm, any emotional harm that I know of. Now, if I did emotionally assault somebody, then that wasn't my intentions. I tend to speak from the mind, and sometimes, yeah, my anger gets to me, Nobody's perfect. You're all human. You all have anger issues at times, some things bother you. Now, I ask put yourself in my shoes. If you're trying to become a new person, try and change your life around, trying to be a parent to your child, trying to be a loving husband or wife, and somebody keeps on hindering and putting walls there, restricting you from doing that, preventing you from doing that, how would you feel? You would be angry. You would be furious, but you wouldn't act on it. Okay, sure, I got hit with threats in the 2nd degree. Okay, I understand that. But what they didn't see was that I was angry. I was very pissed off that I was incarcerated again and I couldn't be there for my family. And your microphone's off.
Thank you so much. I would just say, if I wouldn't speak concerning the actual conduct concerning the charges here, if that makes sense.
Okay.
Thank you very much.
I'm trying to go back home to my family. My family, since I've been incarcerated, was homeless. They lost a house, and my wife had to go to a shelter with my son because I wasn't there to help my family or to provide for my family. I'm pretty sure almost everybody here is a mother. You would want your son to have his father in his life. Because look at the situation that I'm in. Someone like me wasn't raised with a father. I became a gang member. My history is destroyed because of the things I've done in the past. I'm trying to move forward, trying to give my son something I never had. All I ask is that have mercy on me. Let me try with a new parole officer that doesn't discriminate against me because of whatever reason. I have no idea, but I felt like I was being discriminated against. Like a keyword, felt. Let me try with this new parole officer because the new parole, the older parole officer before the one I had, right, the victim, didn't have an issue with me whatsoever. Even when I was the victim's parolee, there wasn't an issue until I was taken from my family, ripped away from my family. Again, I'm asking for mercy. Let me be the father that I'm trying to be. Let me go home. Let me get my life together. Let me do what I have to do. I mean, there is a reasonable probability that I will live and remain at liberty without violating the law. My release is not incompatible with the welfare of society. Your mission is to facilitate the successful reintegration of offenders such as me into the community. Your job here is to reintegrate, help me reintegrate, not to prevent me from reintegrating. Preventing me from reintegrating is incarcerating me over, I wouldn't say petty matters, because I understand this is a serious matter. But there are far more serious matters out there to be worried about. The victim is at no point in time going to be harmed whatsoever. And you have my word. God is my witness. I'm not even thinking about her every day at all. My concern is going home, doing the right thing, going home to my family. As you can see, all I'm doing is talking about my family because that's my main concern, and doing the right thing. So please, I ask you again, have mercy on me. Thank you.
Thank you, Mr. Vasquez.
Thank you.
Any additional comments from either side? Anything new information?
Yes, I would like to speak to that, just his statement. These are not opinions, these are facts. A family man doesn't put your child at risk when you're pepper spraying your roommate. You're still just sitting here directing blame at authority when you are the one on parole and you're the one that has rules to follow. And you just admitted in your own words that you have anger and it continues to get to you. Even during this hearing, you're telling everybody that you plan on having contact with your minor son as a family man, but you're not allowed to. We have reintegrated and given years of opportunity to this offender, and I really believe that a precedent needs to be set today. Thank you.
Years of reintegration to my family. I don't understand. You're saying that I was given years to reintegrate, to be a family man with my son and stuff. My son was just born in 2024.
And Mr. Vasquez, if I may, just very briefly, I would just note that, I don't think his statement by any means is him stating that he's going to have, unallowed contact with his son. But going forward at some point, my client won't be on parole at some point, and he's going to at some point be in his son's life. And so he is just asking for the appropriate steps to move forward in the right way. Thank you very much. Yes, if there's anything that is new, you can put it on the record at this point, Mr. Vasquez.
That situation with the roommate getting pepper sprayed was situated by the police officers at the scene. Police officers checked my hands with their body cams on, by the way, checked with the cameras, and even checked my room. There was no way, shape, or form that there was any chemical agent used by me. There was no way to prove that it was me that sprayed the individual.
Thank you, Mr. Vasquez.
Thank you.
I don't know where they went, so I guess I'm just gonna take a quick moment and then I'm gonna announce my findings at this point. Yeah, I'm gonna just take a few moments. I just want to review everything again before I do make that recommendation. So I'm gonna go off the record. Just want to let everybody know that we are live streamed. So just be mindful of that. So I am back on the record. I have reviewed all the evidence submitted. I've also read statements. I've listened to the testimony today. And I am going to just note some things for the record before I do make that recommendation. So this is a serious offense. Not minimizing it at all. The courts did sentence Mr. Vasquez to 9 months for the threatening second. As stated throughout this hearing today, This is his third violation. The first was a failure to register. He received a 2.5-month sanction for that. The last one was a technical violation, which was the one that expired. I think it was August 25th, 2025. So he received that sanction for that behavior as well. There is a long noted, as stated by counsel, a long noted history of compliance on supervision, as he was released in 2020 to special parole, and his first violation with but with a criminal violation with a failure to appear happened, I think it looks like 4 years later. Again, I did listen to everything, but with that, Mr. Vasquez, I am going to recommend your parole be revoked and that you serve an approximate 1-year period of confinement as a sanction. That's with the re-parole date of August 25th, 2026. And I'm going to recommend the following conditions: behavioral management program for anger management, no contact with co-defendant Terrence Ortiz or Lester Quinteros, no contact with victim MJ and LJ, no contact with minors, a problem sexual behavior treatment and mental health evaluation and treatment as deemed necessary, and halfway house placement with the Hartford location, I think I read listed. And that is my finding and recommendation. So what happens next is that my recommendation is going to go to the board next week on December 18th. On that date, the board can do 3 things. They can adopt that recommendation if they choose to do so. They can lessen it if they choose to do so. And if for any reason they would want to see a period of incarceration longer than what I have recommended, they will bring you back for a 3rd hearing to address any questions, concerns that they may have in order to justify or to set a a sanction longer than what has been recommended at today's hearing. So that does conclude the revocation hearing. Any questions?
Mr. Vasquez, I'll set up a legal call with you so that we can kind of debrief everything. And I can also reach out to Jenny as well, just to give her an update on what happened today.
Thank you so much, Attorney Hannah.
Thank you.
So this does conclude the revocation hearing for, sorry, I missed your first name. So Mr. Vasquez, inmate number 297854. All right, thank you, everybody. Good luck to you, Mr. Vasquez.
Thank you so much. Have a wonderful day and have a happy Christmas.
Thank you.
Thank you, everyone.
Thank you, Officer Devine.
Thank you. Bye-bye.
You're all set, Mr. Vasquez. You can go let the CO know.
Okay, thank you.
Thank you.
Wait this morning.
Hello, thank you all for your patience today. I really do appreciate it.
You're welcome.
Thank you. You're Mr. Williams, correct?
Yes.
Great. I think your attorney is here with us, correct, Jones? Yeah, she is. All right, so we're gonna get started.
Good afternoon. And I could just, before we get started, I know you have to put some things on the record, but I was able to talk to my client for the first time today. Unfortunately, I'd been trying to speak with him since December 1st. He was moving facilities. Every call I had was canceled. But I was able to speak with him today, and we discussed waiving the preliminary hearing, understanding we would have to do it on the record because of the timing. But I just wanted to place that on the record before you went too far into the hearing.
I appreciate it. Thank you for your guys' patience with me. So yeah, I'm just gonna state that this is a preliminary hearing. Sorry, let's start again. This is a preliminary hearing concerning Javon, did I say that right?
Yes.
Yeah, all right, Javon Williams, inmate number 394033. Today is Thursday, December 11th, 2025. I do just want to accept the waiver by counsel on the record. Conceding to probable cause. With that, the finding will be made based on that waiver, and you will be the act is serious enough to further incarceration. So what happens next then, Mr. Williams? I'm sure your counsel explained it to you, but we will wait until those pending charges are disposed of in court and then get you back in for a revocation hearing, okay?
Yes.
Sorry to make you wait all day. Do you have any questions?
No.
All right, thank you, counsel. I appreciate you. So this does conclude the preliminary hearing for Javon Williams, inmate number 394033. Thank you
And Miss-
both. Oh, go
Yeah,
ahead.
thank you. And Mr. Williams, I will be back in touch with you like we talked about on the phone. We will go over in a little bit more detail some of the things that we talked about in preparation for the revocation hearing, okay? Okay,
Thank you. Good luck to you, Mr. Williams.
thank you.
Thank you.
No.
Okay, so I just attempted to call Hartford and it went off the screen again. Alan, I know you just came in about Hartford. Be out in a moment to see.
I will give them a call.
Thank you. Oh, hi.
Hello.
Oh, perfect. So we normally call video one, but it's offline. Are you guys having issues in the video
I don't
one?
know what's going on with it. Like the screen is completely blank. So,
Okay, I'm so glad I took it then.
all right. So
Perfect.
I'm gonna put him in the room and
Perfect.
all righty. One sec.
Thank you so much. I appreciate
You're
it.
welcome. No problem.
Officer Barrios, are you able to connect in when he gets in? Are you here still? I know it's been a long day for being connected.
Yeah. Yep.
This one right here.
Yep, just go in and have a seat right there. All right. And so when you're done, just knock on the door.
All right, thank you.
You're welcome.
Hi, Mr. Briett, how are you?
Good, how are you?
Good. So your officer wants to be present today. She did log in when it was your scheduled hearing time. She said she's gonna try to come back. She's still logged in. I'm just trying to get in touch with her to see if she wants to, if she's around to be able to come in quickly. So just give me a moment and we'll get started, okay?
Okay, no problem.
Thanks.
So I guess they were trying to call that on the first conference room, but that's pretty like. You called on the second, so just let me know what, here right now. I don't know, do I need to put in a work order for that person? Or? No problem.
I'm gonna try to call her. Officer Barrios, are you with us?
Just spoke to Officer Barrios. She's gonna come right in.
Thank you so much. I appreciate it.
Hi, give me a minute, please. I'm getting the paperwork.
Absolutely. Let me know when you're ready.
I'm almost got it here. Hold on.
That's a nice pen. All right.
Okay.
All right. Have a good one.
Okay.
Ready? All right, we are gonna get started then. Thank you. I want to just thank you both for your patience with me today. We were very behind. We're gonna get through this. So good afternoon. I am Parole Officer Chisella, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Millie Briette, inmate number 371781. Today is Thursday, December 11, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Hartford Correctional Center. Can you please state your full name and DOC inmate number for the record?
My name is Willie Briette, inmate number 371781.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. Present this afternoon is your charging officer. Can you please identify yourself for the record? Yeah, Officer Barris, and you all.
I'm
the
sorry.
video-
I'm sorry. I had to close the door.
Oh,
for
that's
the
okay.
office. I'm sorry.
No, you're okay. Can you just please identify yourself for the record?
Parole Officer Barrios.
Thank you. So this is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. I do want to let you know, Mr. Briette, that you also have the option to waive today's preliminary hearing, conceding to probable cause due to having new criminal charges that are pending. What that means is that today's hearing will be concluded, and once the pending charges are settled in court, we will be notified by Parole and Community Services, and a revocation hearing will be scheduled. If you do choose to waive today's hearing, we will review all the rights that you are waiving before we conclude today's hearing. So at this time, Mr. Briette, would you like to move forward with today's hearing?
Yes, I would. Just certain things I won't answer because of, certain things.
Absolutely,
But-
we'll get to that part, definitely, then just I'll be reminding you of that you have in any case, okay? All right,
Okay.
so then, we're gonna go over, so you should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath, so Mr. Briette and Officer Barrios, can you both please raise your right hands? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. So we're going to go over the procedure for today. So first, I'm going to read your rights. Then we're going to review the parole violation charges that the state, your parole officer is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will then have an opportunity to address the issue of probable cause and the severity of the allegations. And after the state is finished, you will have the same opportunity. At the conclusion of this hearing, I will inform you of my findings, which will be based upon the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, I do not.
Did you have important rights at today's hearing? So the first is you have the right to be represented by an attorney. You may hire your own attorney, and if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. So Ms. Briette, were you informed that an attorney could represent you at today's hearing?
I was told that I would be able to have, but I'm just, like I said, there's certain things I'll answer and certain things I won't for now, you know?
So you're willing to move forward without legal representation?
Yes, that's fine.
You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
From Ms. Berrios, right, the paper?
Yes.
Yes,
Yep.
I received that.
Yep. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes, I do.
So we're now going to review the charges that the state your parole officer is bringing against you and the information underlying each charge. So Officer Barris, can you please start with charge number 1, the condition of obedience to the law, and then read the violation details? Oh, you're muted.
I always forget, mute, unmute, mute.
Me too, no problem, go ahead.
Okay, obedience of the law. On November 21st, 2025, parole conducted a routine home visit at your approved parole resident, 50 Coolidge Street, New Britain, Connecticut. During the home visit, parole officers searched the basement and located a large black bag with presumed narcotics such as cocaine and marijuana in a pink safe that was locked. You admitted that and took responsibility for the black bag and the pink safe. Parole officer also searched your bedroom and a loaded firearm and narcotic items were located in a dresser. The firearm was a high point CF 380 388 CP serial number P6169425, which you admitted and took responsibility for the firearm in your dresser and narcotic items located on top of the dresser. New Britain PD responded to the scene and a search and seize warrant was issued for 50 Coolidge Street, New Britain, Connecticut for firearm and narcotic related items and was granted. Upon the execution of the search warrant at 50 Coolidge Street, New Britain, Connecticut, a large quantity of illicit narcotics and controlled substance were located inside the home, which includes marijuana, 1935 kilograms aggregated weight, cocaine, 118.6 grams, meth, 67.1 grams, heroin, 3.7 grams, methamphetamine, 16 pills, MDMA, 2 pills, ecstasy, 1 pill, benzo, 12.5 pills, cash, 1421 USD, narcotics proceeds, and a scale. The narcotics were field tested and yield a positive presumption confirmation of illegal controlled substance. You were placed under arrest for violation of Connecticut General State 53-217C, criminal possession of a firearm, 21A-279A1, possession of controlled substance, 21A-277. C, operating of a drug factory, 21A-277A, 1B plus possession with intent to sell hallucinogen, 2127A1AI, possession with intent to sell greater, and 21A27AB, 1D, possession with intent to sell 1 kilo or more of cannabis. And based on your behavior, you are in violation of parole condition, obey or loss, obedience of the law. Charge number 2, drugs on 11/21/25. Parole concluded a routine home visit at your home. Parole resident, 50 Coolidge Street, New Britain, Connecticut. During the home visit, parole officers searched the basement and located a large black bag with presumed narcotics such as cocaine and marijuana and a pink safe that was locked. You admitted and took responsibility for the black bag in the pink safe. Parole officer also searched your bedroom and narcotic items were found on top of the dresser. You admitted and took responsibility for the narcotic items located on top of the dresser. New Britain PD responded to the scene and a search warrant, seize warrant was issued for 50 Coolidge Street, New Britain, Connecticut, for firearm and narcotics related items and was granted. Upon the execution of the search warrant at 50 Coolidge Street, New Britain, Connecticut, a large quantity of illicit narcotics and control substance were located inside the home, which included marijuana, 1935 grams substance were located inside the home, which include, I'm sorry, I read that already. Aggravated weight, cocaine, 118.6 grams, meth, 7.1 gram, heroin, 3.7 grams, methamphetamine, 16 pills, MDMA, 2 pills, ecstasy, 1 pill, benzo, 12.5 pills, cash 1421 USD, narcotic proceeds, and a scale. The narcotics were field tested and yield positive for presumed confirmation of illegal controlled substance. You were placed under arrest for violation of Connecticut General Statutes 21A 279A, possession of controlled substance, 21A 277C, operating a drug factory, 21A 277A B1B, plus possession with intent to sell hallucinant, 21A 278 A1A II, possession with intent to sell greater than 1 ounce of cocaine, 21A 277 A1A, possession intent to sell narcotics, and 21A 278 B1G, possession with intent to sell 1 kilo or more of cannabis. Based on your behavior, you are in violation of your parole condition or bail laws, drugs. Charge number 3, weapons. On 11/21/25, parole conducted a routine home visit at your approved parole resident, 50 Coolidge Street, New Britain, Connecticut. During the search, parole officer searched your bedroom and located a firearm. Loaded firearm was found in your dresser. The firearm was a High Point CF 380 CP, serial number P at 6169425, which you admitted and took responsibility for the firearm. New Britain PD responded to the scene and a search warrant was issued for 50 Coolidge Street, New Britain, Connecticut, for firearm and narcotics related items and was reviewed and granted. You were placed under arrest for the violation of General Statute 53A 217C, criminal possession of a firearm. Per your parole conditions, you are not allowed to have in your possession or control any firearm, ammunition, or any other weapons. Also, you are registered on the Connecticut Deadly Weapon Offender Registry, which prohibits you from possessing or being in the vicinity of any type of firearm or ammunition. Based on your behavior, you are in violation of your parole condition or bail laws, weapons.
Thank you. You've also submitted evidence in support of the case. Can you please identify the evidence for us? Yeah. Going back to
You want me to review the evidence?
Yeah, can you please read off the evidence that you've submitted?
Okay, Exhibit A, condition of special parole. Exhibit B, remand of custody. Exhibit C, parole violation report. Exhibit D, notice of parole violation. Exhibit E, New Britain police report, case number 25000-76330. And Exhibit F, 7 photos.
Thank you. Mr. Bria, just to confirm, you did receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes, I did.
And you were able to review all of that information?
Yep. Yes, I was.
We did not receive any exhibits from you at this time. Do you need any time to submit any evidence for your own behalf?
As of right now, no, just the opportunity to just, say there was just one thing in the report that just wasn't mentioned. And that was the one thing that I just wanted to state.
No problem. So we're gonna move on to that then. At first, the state is gonna go first because they have to state the case. So at this time, it is Officer Barrios's opportunity to make a short statement, call any witnesses to testify with respect to probable cause and the severity of the allegations. After she's concluded, you'll have your opportunity, okay?
Okay, thank you.
Thanks. Go, Officer Barrios, would you like to make any statements towards the case?
Really not much, but the charges are clear of what was found that day at the home. And from the search that the police officers render for the warrant, specified more in detail of what was found at his residence, him knowing that he is not to be around or in possession of any of these items.
Thank you. And now, Mr. Bria, you're all set, Officer Barrios, sorry.
Yes, yes,
Okay,
I
thank
am.
you. It is now your opportunity to respond to the violation charges against you. Remember, you do have the right to remain silent if you choose to do so. And just, I know you're aware of it, you said what you said, but just remember everything is live streamed, video recorded, and you have pending charges, so just be mindful, okay? So would you like to make a statement at this time?
Yes, the only thing that was in the parole, I guess the violation report that Mrs. Barrios had submitted to me was that when they had searched, they had found everything. I had clearly stated that all of it was not mine. I took responsibility for it because they had put my wife in custody. My 16-year-old son watched, both of his parents get arrested. I made it clear that everything that was down in my basement, it was not mine. I had made that clear. I said I took responsibility for it. As Ms. Barrios knows, I said I took responsibility for it, but it did not belong to me. And that's the one thing that I want to be on the record, that I had no idea what was in the pink safe. I couldn't open the pink safe. I didn't have the key to the pink safe. There was no combination to the pink safe. The pink safe had belonged to a deceased friend of mine, which I planned on getting rid of, and it should have not been in my house. And, unfortunately, everything else just, it happened the way it happened.
Okay. Thank you. I do appreciate your statement.
Thank you.
Thank you. Anything further from either side before I do announce my findings?
I just want to clarify that he did make those statements, but because they're in his residence and we don't have proof of who they are, we have to proceed it that he is responsible for those items.
The monitor itself is no problem.
Thank you. Mr. Bria, I saw you.
Yeah, the one thing I did want to state is Mrs. Barrios can confirm this. The entire time that I was on parole, I had followed every rule, every order down to a T. I was working. I ended up hurting my back. I was on workers' comp. I provided proof of that I've had back surgery. I've had needles in my spine. Everything that led up to the events, I was in compliance with the entire time. She's never gotten a dirty urine for marijuana, for cocaine. She's never gotten a dirty urine from me at all. She's never had an issue with me reporting or showing up late. I follow parole to a T. This is just an unfortunate circumstance that just should never have happened.
Anything further from either side?
No, I'm set. Thank you.
We'll just take a quick moment, then I'll announce my findings. So.
Nothing?
So on charge number 1, Mr. Bria, I am making a finding of probable cause based on the evidence submitted by states exhibits A, C, and E. I'm also making a finding of probable cause for charge number 2, the condition of drugs based on states exhibits A, C, and E, as well as charge number 3, the condition of weapons based on states exhibits A, C, and E. I'm also finding that the acts are serious enough to warrant revocation, and I've also determined that you should be detained while you await your revocation hearing. So we'll notify the records office at the facility. Your parole officer is aware of it now. So what happens next, Mr. Bria, is that once that case is concluded in court, we will be notified by Officer Barrios of the disposition of it and bring you back in for a revocation hearing. At that revocation hearing, myself or another hearing examiner will determine whether you have violated the conditions of your parole. And if so, if it is determined that you did, that hearing examiner will recommend sanction. Will recommend whether your parole should be revoked and if or what any sanction should be imposed at that point in time. Okay. Do you have any questions for either of us at this time or me?
No, just a statement to Ms. Barrios. So I apologize for messing up. This is just a mistake, you know, like I apologize for you going through all this. You know, I was doing good. I appreciate everything you did for me and my family. I do.
Thank you,
That's
Brennan. Thank you.
Thank you. All right, so this does conclude the preliminary hearing for Willie Briette, number 371-781. Good luck to you, Ms. Briette, and we'll see you once that case is done in court, okay?
All right, thank you.
All right, take care. Thank you, Officer Barrios.
Okay, thank you.
Have a good one.
I have a question.
Hold on, Alan.
I'm gonna go ahead and end.
Thanks.